Okay. Again, thank you for your patience. I think we're ready for the jury. I have one change to the jury charge that you'll get to see when you get the final version. I hadn't included language to the effect that any evidence that the jury received about statements Mr. Tolbert made to law enforcement should be used only against Mr. Tolbert, because I didn't think that was going to be applicable, because I thought things were going to play out in a slightly different way, but they didn't. So I'm going to put that language in. You all can see it, but it's basically the limiting instruction that I gave to the jury when before Detective Summers began talking about her interview with Mr. Tolbert. You have any issue with that, Mr. Trepanier?
No, Judge.
Ms. Feely?
No.
And Mr. Francis? Okay, great. Mr. Trepanier, anything we need to get on the record before we get started?
No, Judge.
Ms. Feely?
No.
And Mr. Francis? Everyone's ready to go. Are you going to be opening and closing?
Yes, Judge.
Okay, then let's bring the jurors in. I'll explain to them the plan, and I will do my best to have a morning break be between closings. I don't know that we'll get all the closings in. We have to stop for lunch at about 12:10. It's our monthly bench meeting, which remains virtual, but I have to be on that at 12:15. So lunch will be 12:15 to 1:15. And hopefully we'll be able to have breaks occur at natural times in the closings. All right, let's bring them in.
All right, jurors.
You all can be seated. Good morning, ladies and gentlemen.
Good morning.
Thank you for being here on time, and thank you for the chocolate chip cookies. That was very thoughtful and very tasty. Got now a serious competition between this jury and the Cupcake Pimps jury. So it is Thursday, and we're starting a little late. I had to chat with the lawyers about some things and had some morning meetings. But we are where we left off. And if you don't recall, that is closing arguments. So this is an opportunity for all three lawyers, if they choose to argue to you what they think the evidence has shown or failed to show. It is an effort to persuade, and you should feel free to be persuaded if you find it persuasive, but it's not evidence. If a lawyer tells you, by golly, this is what a witness said, that may be your recollection, but the lawyer telling you that doesn't make it so. You decide what the evidence is. Obviously, the physical evidence is what it is. And there'll be nothing new on that front, but this is a chance for the lawyers to bring together all the loose strands, and they'll probably talk to you a little bit about the law, and they're free to do that, but you'll actually get the law from me at the end of these closings. As I mentioned yesterday, because the state has the burden of proof, They have a chance to open and close with closings. And Mr. Trepanier has indicated that's exactly what's going to happen. So he's going to get up in a moment and give his initial closing argument. Then we'll hear from Ms. Feely and Mr. Francis if they choose to give closings. I suspect they will, but they don't have to. No burden of proof. And then Mr. Trepanier will have a chance to have that final word. And then we'll be done with the lawyers. I'll give you the charge and you'll be off and running deliberating. I don't know that we'll get through everything before lunch. Lunch is going to be at around 12:10, 12:15. I have a Zoom meeting with all the other judges from 12:15 to 1:15. So that's when you're going to have lunch. And whatever we haven't finished, we'll do right after lunch. And then you'll do your deliberating. Mr. Trepanier, when you are ready.
Good morning, members of the jury. Again, this is the state of Georgia versus Ramel Williams. I want to thank you on behalf of myself and Mr. Consett and the state of Georgia for having paid attention throughout this trial. Obviously, some of this evidence is something that can be difficult to hear and difficult to see. And so we thank you for sitting there and keeping an open mind and taking that all in. So we're going to hear about this a little bit more, but the burden of proof rests with the state. We have to prove every element of the crime charged beyond a reasonable doubt. And the state embraces that burden. And in this case, the state has met that burden. I want to talk about the presumption of innocence. The legal presumption until the state proves beyond a reasonable doubt that these defendants committed the crimes. But it doesn't mean that these defendants are actually innocent. So what you heard about the presumption is that's what they walk in. It's like a cloak. They walk in with this cloak, this presumption of innocence, until as pieces of evidence start to come out, that cloak is removed. And as they sit here today, that cloak has been removed, and these defendants are guilty of murder, felony murder, armed robbery, aggravated assault, possession of firearm during commission of a felony, and as it relates to Mr. Ramel Williams, possession of a firearm by convicted felon. So let's talk about the juror's duty, your duty in this case, just a little bit. Your job is to search for the truth, okay? What really happened based on the evidence? Apply the law to you. In this case, what happened was that Frank Flute III was walking south of the Riverside Drive West. These defendants saw him. They saw this man walking alone at 3:30 in the morning, and they made that U-turn and they came around and stalked up on him and got behind him, came up to him, stopped their car, got in a tussle with him, and ended up shooting Mr. Frank Flute one time. Causing a gunshot wound up his leg, causing him to bleed out and die. You have a duty to follow the law. And you're going to be bound by the instructions of the law given to you by the judge. And like the judge said, that is what you're follow. I'm going to discuss it a little bit, but what's important is you are not to become an advocate for either side. It's your duty to deliberate as well. The juror refuses to deliberate with or discuss evidence with other jurors, bring this to the judge's attention. So let's go over what you can and cannot consider. So what I've got here is a circle. And what you'll see on the outside of the circle are things you shouldn't be considering. And on the inside are things that you can consider. So passion, should be considering passions. Public opinion is not what this is about. Disliking the police. Sentiment, having sympathy for the defendant or defendants. Disagreeing with the law. Conjecture, penalty and punishment or prejudice. So those are things that you should not be considering when you are deliberating. But what you are considering are the elements of the crime. And I'll go through each of those and they will be in the jury charges that this judge will give you. The law. The law is what you need to consider. You need to apply the facts as you find them to the law. Expert testimony. So in this case, we had several different experts come and testify, including Detective Leon Packer, who said that the handsets, the cell phones belonging to both of these defendants, started out at that Center Hill Drive area. Those handsets kind of traveled east towards the crime scene. They're around that crime scene. They go north a little bit, they come back and then travel west again, back towards Center Hill Ave. Perfect Lawrence Satcher indicating that they were 45 caliber shell casings, 2 of them fired from the same firearm, 45 caliber pistol and handgun. Raymond Lauzon said the fingerprints in this case that he was able to identify Mr. Tolbert's on the passenger side of the vehicle. The passenger side. So what does that indicate? Mr. Lamont Williams driving his car. We also heard from Dr. Henniger, obviously. But you also can consider the photos and documents that you saw in this case. That's evidence. Testimony of the witnesses. What they testified about. How many gunshots they heard. What testimony from one witness corroborates the testimony of another witness. All those things are things that you should be thinking about while you're deliberating. The credibility of witnesses. What reason would a witness have to have a bias in the case? For example, Alicia LaFleur. She said that she loves Ramel Williams. So consider that when you're considering her testimony. The defendant's actions, as you hear, what did they do? They fled to Chicago. Together. They're together in Chicago. They're not separate places, they're together. After this happens, several weeks after this happens. When Ramel Williams has, the day of the incident, been told that, hey, your girlfriend's vehicle was used in a murder. And then he goes to Chicago for several weeks where he's arrested. What is the defense? You can consider that. Does it make sense? Fleeing. I've already talked about this. You can consider that as well. In your common sense, and this is an important one, because there are a lot of things in this case that when you start to apply your common sense, obviously ends up making sense. Who was in that vehicle? 2 people. There's 2 people in the vehicle, then, and the cell phones are showing movement, then obviously the 2 people are Mr. Williams and Mr. Tolbert. Ms. LaFleur's cell phone is at her house. There was nobody else who had access to the vehicle, common sense. So reasonable doubt is the doubt of a fair-minded and impartial juror honestly seeking the truth. You are not seeking doubt. It's not doubt beyond all doubt, or just some sort of mathematical certainty. Reasonable doubt. Let's go over the charges in this case. Murder, felony murder, armed robbery, aggravated assault, possession of a firearm during commission of a felony, and as it relates to Ramel Williams, possession of a firearm by. So murder. Person commits a murder when that person unlawfully and with malice aforethought causes the death of another human being. So what is malice? It's the intentional killing aspect of it. It's the deliberate intention to unlawfully take away the life of another human being. And can be shown by external circumstances capable of proof. So, and it can also be implied. So when the circumstances of a killing show an abandoned and malignant heart, something mean, nasty. So evidence of malice in this case. A malignant heart that's circling and following a friend. Shooting him after a struggle. We heard about this struggle. Brian Wiley testified about the struggle over something. Maybe it was the firearm. Probably was the firearm. Because it was the firearm. Because during the struggle, it shot. We know it was likely during this struggle because of the way that bullet went through Mr. Fluke. He was not just standing straight up. There was something going on. And importantly, multiple shots. This is not a one shot. Okay, no, this is a multiple shots, shooting at him twice. The gun jamming at some point, needing to clear that jam. Either to throw out fire the third time, or jamming at the first trigger pull, and unclearing that jam to fire shots, or in between. But whatever it is, that shows that intention to kill. The intention to kill. Now, criminal attempt does not mean an intention to violate a law or to violate a penal statute, but the intention to commit the act that is prohibited by statute. And you can infer that from the evidence. It can be inferred when it is a natural and necessary consequence of an act. So, what is the natural and necessary consequence of shooting someone? When you shoot at someone, it's reasonable you intend to kill them. When you shoot more than once, it reinforces that. The natural and necessary consequence of shooting someone is that they're going to die. The proof of motive is something, it's not an essential element that is part of this. The state is not required to prove motive. If anything, motive can help you to determine the state of the defendant's mind at the time of the thing. Okay. Now let's talk about felony murder. A person commits felony murder when they cause the death of another person by committing a felony. So the defendant doesn't have to have acted with malice for felony murder, which means they don't have to have intended to kill anyone. As long as they are committing that felony and a death resulted, they're guilty of felony murder. By committing an armed robbery or an aggravated assault, which caused the death of Mr. Frank Fluke III, these defendants committed felony murder. And we'll talk about them acting together. It's called parties to a crime or conspiracy. But by just engaging in those acts, just the shooting, whether or not there was an intent to kill, by just doing the act of shooting at Mr. Frank Fluke III, they committed a felony which resulted in his death, meaning there's a felony murder. Same thing with the armed robbery aspect of it. And as it relates to Mr. Romel Williams, because he was a convicted felon in possession of a firearm, he was committing that felony, and what resulted as a part of that was the death of Mr. Frank. I think about felony murder, and I think sometimes it's a good way to think about felony murder, is a bank robbery scenario. A couple people go in to rob a bank, right? Maybe they don't even have guns. Maybe one of them has something. It doesn't really matter. But one of them goes in and the security guard sees this and there's some sort of threat and they kill one of the people committing the bank robbery. Felony murder for whoever is there. Or someone dies as a result of it. So there's no intent to kill them as long as the felony, as long as that crime, that armed robbery, that aggravated assault, whatever it was, ended up causing the death of Mr. Frank Fluke III, you have a felony murder. That's what we have in this case. So let's talk about armed robbery. A person commits armed robbery when they take another person's property. The book bag, right? The book bag that you clearly saw on two videos, the Vic video, right? Him walking down with that book bag on. And then you can see it in that Georgia Tech video, walking down the street. And when officers arrive, they're on there securing the scene, there's no book bag. From the presence of Frank Fluid, how do we know it was in his presence? Because he had it on effect. All right, using an offensive weapon, the .45 caliber pistol, and with the intent to commit a theft, struggling for it, leaving. Again, like I said, using a firearm to take the book bag belonging to Frank Fluid gives us the armed robbery. And because Mr. Fluid died as a result of these defendants' actions during that armed robbery, we have a felony murder. They're guilty of felony murder. Same thing with the aggravated assault. A person commits the offense of aggravated assault when that person assaults another with a deadly weapon. A firearm is a deadly weapon. We know these defendants assaulted Frank Fluid with a firearm because they shot him. So Frank Fluid had a bullet lodged in his pelvis. We have shell casings on the scene. We have actual injury, right? And by committing this aggravated assault, causing him to die, they committed felony murder. Possession of a firearm during commission of a felony. So a person commits the offense of possession of a firearm during the commission of a felony when, it's pretty obvious, they have on or within their arm's reach a firearm. And by committing the murder, felony murder, armed robbery, aggravated assault with handgun, these defendants commit that crime. And finally, possession of a firearm by convicted felon. Ramel Williams is a convicted felon. There was a stipulation that you heard between the state and defense representing Mr. Williams that the defendant has that status, okay? And he possessed that firearm when these offenses occurred. So the evidence. So importantly, and this is what I made sure to bring up in opening, is something that was important to consider. Parties to a crime. Every party to a crime may be charged with and convicted of the commission of the crime if directly commits the crime or intentionally helps in the commission of the crime. You can apply parties to the crime to the charges in this case. Conspiracy. I know this is a big paragraph and you're gonna have the jury charges with you, but a conspiracy is an agreement between two or more people to do an unlawful act. So you can see that a conspiracy exists by proof of conduct as well as an express agreement. And when people conspire, any act done by one conspirator to further the conspiracy is considered to be an act of all the conspirators. So each person is responsible for the acts of all the others insofar as the acts are done for the conspiracy. And that's something for you to determine. Was there conspiracy here? And there was. And how do we know that? It's through the conduct of the parties. The presence, companionship, and conduct before and after the commission of the alleged offense may be considered by you in determining whether or not such circumstances give rise to the inference that there was a conspiracy. So, what does this mean? Again, we look to the cell phone records and the vehicle. Who had access to the vehicle? These two individuals. What time did they leave or head out to this Northside Drive Northwest? 3:30 in the morning-ish, a little bit before that. They're traveling that direction. They're traveling that direction together. For what? For what reason at 3:30 in the morning? Some people say nothing good happens after midnight. That's his case. They travel there together. Murder occurs. They travel back together. The investigation starts. And they end up in Chicago. And I'm going to go more into the common sense part of this a little bit later, but start to think about that because Mr. Ramel Williams knew on January 14th, 2019 about the investigation because of the traffic stop. And if Mr. Williams had no idea what happened, the only other people that had access to his vehicle were Alicia LaFleur and D'Anthony Tolbert. So why would you be hanging out with that one other person who had access to the vehicle that was driven as part of a murder up in Chicago 2 weeks later? Unless you knew about it, you were part of it, you were in the conspiracy. Ultimately, it doesn't matter whether it's D'Anthony or Mel Williams who was shot, they were acting together. And it's shown by their movements and footage. So it's your job to determine the credibility or believability of the witnesses. And you can determine which ones you want to believe, not believe, believe part of it, depending on what you perceive. You may also consider their personal credibility as it may be shown in your presence there by the evidence. So did what they say match up with the evidence? What was their demeanor? Did the facts they testified to match the evidence? What did they say? Did anything they say prove to be a lie? Conflicts in testimony. So if you heard conflicts, look at the evidence. How do you resolve that conflict? Did you hear something from another witness? Was there physical evidence? And apply the same thing to whatever the defense says. Look at those conflicts. So direct evidence is evidence which may be heard, sensed, it's your 5 senses basically is direct evidence. It can be brought into court, as you saw, in the form of direct witnesses, testimony, and it points immediately to the issue. So again, it's direct, it's senses, it's testimony, those sorts of things. Circumstantial evidence is evidence of the proof of facts or circumstances that by direct evidence, which you infer or put together, that you're justified by doing in light of your experience. It tends to establish a conclusion and question by the consistency of such conclusion or elimination of such conclusion. So an example I like to use for circumstantial evidence is, how do you know you filled a car's gas tank with gas? And the reason why I like this is because when you go to a gas station, what you are doing is using circumstantial evidence to realize that you now have gas in your car, because you don't actually see that gas in your car when you fill up your tank. You can hear the sound of the liquid flowing through the hose. You can maybe smell the gas as it's kind of flowing through there. You might see the gauge changing. You might feel your hand rattling because you feel a flow of liquid, right? That's all circumstantial evidence to show that you have a full gas tank. How do we know these defendants committed these crimes? The circumstantial evidence. The vehicle used, Alicia LaFleur's vehicle, right? And we hear testimony from multiple people that the only individuals who had access to that vehicle were Ramel Williams, D'Anthony Tolbert, and Alicia LaFleur. Okay? So we have a universe of 3 people who had access to that vehicle that night. 3 people. Okay, so then how do we know who was involved? Let's talk about when and where and how that vehicle is returned. All right. How do we know that Ramel Williams was the driver of that vehicle? Why and how? It's because that vehicle came back in time for Alicia LaFleur to get to work. Go get to work at the airport. She had a early job, right? We see that vehicle traveling west right before 4 o'clock to get back to that Center Hill Ave address. The cell phone records. The cell phone records show these individuals' phones moving together, right? Following kind of the path of the Vic camera. Being at the crime scene. The flight together, to being together. Yeah, I'm gonna go through reasonable doubt a little bit again. Like I said, that of a fair-minded and impartial juror honestly seeking the truth. You're not to seek doubt. And it's not some sort of mathematical certainty or all doubt. It's not all doubt. Okay. One of the examples I use, I've got a couple here involving the same sort of thing, is you look at that. And you know what that is. It's George Washington on a dollar bill. I think this example may be starting to get kind of old because very few people carry currency anymore, but it's still pretty relevant. You know what that is. You don't have to see the whole thing to be able to conclude what that is. You don't have any doubt as to what that is. Same thing with this. Puzzle pieces, right? You know that's a dollar. There are pieces missing out of it, but you know what it is. A reasonable person does not have to see every possibility to know what something is, right? It's not a vague or arbitrary doubt. It's a doubt for which a reason can be given. So another thing to consider is, got no personal baggage in the jury room. This is not about a personal agenda, a political view, issues with the justice system, trying to make a personal statement. That's not what this is. You're not an advocate for one side or the other. What you are here to do is determine the facts and apply them to a law. Single witness corroboration. Testimony of a single witness, if believed, is generally sufficient to establish a fact. There's no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. About venue. State has approved venue. Venue is where the crime occurred, what county. Fulton County is testified to by multiple witnesses in this case. So now let's go through some of the evidence. The 911 call said, they shot me. They shot me. That immediately triggers, it's not he or she, it's the they. Mr. Frank Fluid III saw they. They were involved in what happened to him. The Georgia Tech video, the video, the LPR reads, what do they tell us? We know what vehicle it was. We know who had access to the vehicle because of it. These defendants decided to prey on Frank Fluid, making those U-turns to follow the victim. Frank Fluid was alone. You could see that he wasn't walking with a group of people, right? He was prey. He was an easy target. 3:30 in the morning, walking by himself, southbound on Northside Drive, Northwest. And as you saw, it wasn't like there was a ton of traffic going around. It's 3:30 in the morning. What does that big video, Georgia Tech video do? It also corroborates Brian Wiley's testimony at the event. You can ask to watch whatever you want again. So let's talk about Brian Wiley. He sees the struggle, says he pulls up. They're fighting over something, right? Fighting over something. It's a tussle. Gunshot. He's turning around. He's getting waved on. And what's interesting is he sees two people. So he's in his car, another car comes by, and he sees two people in that vehicle. Two. Again, who had access to the vehicle? Alicia LaFleur, Jermel Williams, Anthony Tolbert. So how do we corroborate that there were two people? The cell phone record showing both defendants' phones, handsets, traveling that route, right? Shredda Thomas. She sees the vehicle circling. It seems suspicious. She hears multiple gunshots. Okay. So what helps reinforce that, right? It's confirmed by the shell casings, right? She heard a gunshot. We see shell casings. She saw vehicles circling around. When you look at that video, you can kind of see vehicles circle. Sergeant Barmender. He arrives and secures the scene with the other officers. It's important is that there's no backpack present with the victim. This is proof that the armed robbery occurs. This is clearly visible in that video. Clearly visible. It's not a little thing. That's a big backpack, and it's not there on the scene. And we know that it's not there at the hospital with him. That backpack is gone. And of course, we don't have the backpack because the backpack is what these defendants took. If they didn't take it, and they didn't do this, then of course it would be there. Mr. Frank Flew would still be alive. Talk a little bit about Alicia. She indicated there was only one set of car keys, and what you heard from Detective Benton after Alicia LaFleur testified is that Alicia LaFleur, after that traffic stop, said the keys went from her nightstand to the kitchen area, right? So let's think about that for a second. Let's think about that. Alicia LaFleur is in a room with Ramel Williams. Do we really think DeAnthony Tolbert came walking into the room while Ramel Williams and Alicia LaFleur were sleeping, came up to the dresser, grabbed the keys, and then just went himself? That makes no sense. That makes no sense. And it makes no sense, especially in light of the fact that if that's what did happen, why would Ramel Williams then be hanging out with him in Chicago 2 weeks later? I think a reasonable person would be quite angry that maybe you used my vehicle in an armed robbery and a murder. If it wasn't me, I wouldn't be hanging out with them. I don't think that's a reasonable conclusion to make. Alicia LaFleur also said she didn't let DeAnthony drive the vehicle. Ramel Williams would have known that. And what's interesting is, and we'll get to it, where is the fingerprint? DeAnthony Tolbert's fingerprint is on the passenger side of the vehicle, which also indicates Ramel Williams would have been the driver. Alicia LaFleur. She said it, she loves Ramel Williams, right? She has a child with him. She didn't question him when he said they were investigating practice. Maybe he drove by later, I think is what we heard. Maybe that's why the car is being investigated. Maybe I drove by later in the day. I dropped you off, maybe I had the car and I drove by later. That's wrong. That doesn't make sense. Just trying to cover his tracks. He's trying to make that relationship work. She didn't really question him about it. She probably didn't question him because she didn't want to know the answer. They went up to a funeral, but they didn't come back. Apart from Alicia saying that there was a funeral, there's been no evidence of any actual funeral or family emergency. And again, defense says no burden, right? No burden. But I would say that it would be easy to be able to pull up an obituary today's day and age. With the internet, funeral home, type the name in, okay. Again, this reinforces that Ramel Williams was fleeing. He's not trying to come back. Alicia LaFleur had a job. Ramel Williams had a job. They go up for a funeral, and then they stay, abandoning jobs. They're not trying to come back. Al Vasquez, Ramel Williams stopped showing up to work. They kept that job open a long time. He stopped responding about coming back. Okay, got a family emergency. I'll be back on the 21st. Is it still going? 21st rolls around. Oh, no. Can't be back. He abandoned the job because the defendants murdered Frank Flew here in Atlanta. Ring was on. DeAnthony Tolbert's fingerprint was on the passenger side of the vehicle. Ramel Williams was the driver. He could have chosen. So whoever this driver was, which is Ramel Williams, had control over the situation, right? The driver never had to stop that vehicle. The driver could have just kept going, could have just circled around and gone back home. The driver is the one who had control. All right. Stephen O'Hare, they were arrested together in Chicago. traveling together, committing a murder, both defendants together in Chicago. And again, if Ramel wasn't involved, then he sure wouldn't want the only other person who had access to the vehicle around him, right? Common sense. Lawrence Thatcher, 2 shell casings, finished, shot 1 .45 caliber pistol handgun twice. And the gun must have been jammed for there to be a live round. We heard that from both Lawrence Thatcher and Summer Bennett, right? That to get a live round, there has to be some action of clearing the slide, using that slide to clear the jam. Which again, comes back to that intentional killing. Dr. Henniger. Dr. Henniger saw signs of a struggle and a tussle, once again corroborating Brian Wiley. So now we're corroborating that aspect of what Brian Wiley saw. Trust that he saw 2 people. We have those other injuries to Frank Fluitt's face. We have the earring ripped out. And we know it was ripped out because we have the other one at the crime scene with the back and the diamond portion separated, right? All right, so let's talk about Detective Bennett. She identifies the vehicle involved and the owner. She speaks with Brian Wiley and Sherry Thomas. She gets the video, and this combination of evidence allow us to develop that time, right? So, timeline. 3:29 a.m. Frank Fluitt is on Donnelly Hollowell, headed to turn south on Northside Drive Northwest. That's when he's walking with that book bag on in that big video, headed towards Northside Drive Northwest. Then, at 3:31, the defendant's vehicle makes a U-turn, basically, to follow back and go in the direction, or excuse me, Mr. Fluitt, that shouldn't have been Mr. Wiley. Frank Fluitt then is seen walking south towards the crime scene on the Georgia Tech video at 3:33. 3:34 to 3:35, the defendant's vehicle comes behind Frank's Fluitt's at the utility pole. 3:37, the vehicle leaves the scene by doing that U-turn. The back up, it's a 3-point turn would be the technical term, but goes back again north. The vehicle passes Brian Wiley at the intersection of Donnelly Hollowell and heads north, which is consistent with that cell phone plot that you saw. So when Detective Leon Packer was going over that cell phone plotting, he indicated that around this time, there was a northern plot, and we see the vehicle kind of head north and then come back around, and then we get the outer reef. So that northern plot makes sense in light of the big video and the timeline. We know at 3:39, 911 call is placed by bystanders. We get the CAD report. We know at 3:42, the defendant's vehicle then comes back south on Northside Drive Northwest, turns west on a Donnelly Hollowell, and back towards 874 Center Hill Ave. Again, also consistent with both defendants' cell phones. 3:44, the first responders are on. LaFleur says she was asleep at the time. And what do we know? We know she wasn't there based on her cell phone records. Her cell phone records don't have her moving from her home. The car was there when she had to go to work around 4 a.m. Yeah, so it's not, a stranger taking a vehicle. It's not a hot wiring. It's nothing like that. Keys have been moved from the dresser in the bedroom to the kitchen area. And only her, Ramel, and D'Anthony had access to the vehicle that night. Vanessa didn't live there. She would have not had access to the vehicle at 3:30. And Ramel Williams denies knowing anything about what happened. Starts to deflect. Asks about, the car, maybe it was hot wired or stolen, is what Summer Bennett said. Despite having been in the vehicle during the traffic stop with Alicia and his sister. Okay, that doesn't make any sense. The vehicle had nothing about it that indicated that it had been hot wired or stolen. The keys were in the house. And then he gives his phone number. Summer Bennett eventually talks to Alicia LaFleur. LaFleur tells her that she is in Chicago, but Ramel is in Atlanta. And then Ramel then calls from her number and says he's in Chicago too. It's almost like she's covering for him, and I'd argue that's exactly what she. The cell phone records for Williams show his phones by the crime scene at the time. Gets arrest warrants, learns about DeAnthony's prints, determines DeAnthony's numbers, that 6988 number. Phone records also put DeAnthony in the crime scene. Learns about Williams arrested in Chicago with DeAnthony Tolbert. At that time, there were no murder warrants for Mr. Tolbert. The cell records at that point were still pending. She speaks with him. He admits living on the floor, indicated in driving for his vehicle, states he wasn't seen in the murder, then changes his story. So that's that he was there and she. Kevin Leon, an expert analyzing cell phone data, analyzed LaFleur's, Williams, and Tolbert's cell phone data, was able to exclude LaFleur as being in the vehicle based upon those records, right? Examining Williams and Tolbert's records, we see movement from west to east, which would be consistent with both of them driving towards the crime scene from Center Hill Ave. Tolbert's phone shows lots of timely advanced data around the crime scene. Both devices head north, both devices move south and west for Center Hill Ave again. And it indicates, as Detective Leon Packer said, that the phones were together the whole time. Phones were together, they're not calling each other. It's consistent with the timeline and when Frank Fluke was murdered. Movements are consistent with the vehicle's travel on the big video, and both phones being together confirms Brian Wiley seeing two people. They must be Williams and Tolbert because they were the only two with access to the vehicle other than Alicia LaFleur. So let's talk about some common sense. If Tolbert alone took Alicia's car, then why would Williams be with him in Chicago? It's not reasonable to think that Williams would want to be with the person who put going to be the mother of his children through this, put him through this investigation aspect of it. Is he really going to hang out with the person who used the car? No, unless he was involved, unless he was part of a conspiracy, he was a party to that crime. If it wasn't Williams, then why would Tolbert make sure the car was returned so Alicia could go to work? If he just took the car by himself, why would he be making sure I gotta get it back so Alicia LaFleur can go to work? And clearly, you could tell Alicia LaFleur and DeAnthony Tolbert probably didn't like each other based on what she was saying. And he would have been considerate to what she needed at that point. Now let's talk about some more common sense. If Williams was asleep, his phone would have been with him in that house. It doesn't make sense if you just leave your phone in the car overnight, right? You're not gonna sit there and scroll. Not gonna set your alarm to wake up in the morning for your job. No Facebook, no Instagram, Snapchat, any of those things. And then you might even realize, okay, I forgot my phone in my car. Let me go get it. Right? He coincidentally left his phone in the Chevy Tracker the one night a murder occurred. That doesn't make any sense. Williams was going up for a funeral, then why did both he and Alicia stay when they both had a foot? Right? They both stayed. Explain justice with no intention to return. There's no evidence of any actual funeral family emergency. So a couple things that we need to consider. Doesn't matter if we don't have a firearm. It's common sense that someone's going to just keep it on them after killing someone. We have evidence that it was a .45 caliber pistol handgun. I mean, we have the projectile that was in Mr. Frank Fluke III. And of course, again, we don't have the book bag. If the bag was Mr. Fluke, then there wouldn't have been an armed robbery. So let's talk about the verdict in this case. When you come back in this case, you're going to come back with a guilty verdict because that is what the facts applied to the law in this case did. And when you do that, you're not telling these defendants anything that they don't already know. You're just confirming what they did. In a moment, I'm about to sit down. You're gonna be able to hear from the other lawyers in this case. And after they present, I'm gonna get the chance to come back up and speak. But before I do that, I do want to say once again, I thank you for your time and consideration to this important case.
Thank you, sir. Ms. Feely?
We talked yesterday, Mr. Francis, actually. It's all right.
All right, Mr. Francis?
Thank you, Judge. Evidence against Mr. Tolbert, my client, insufficient to find him guilty of the charge, and I'll tell you why. A lot of what the prosecutor just explained to you is the law, and you're gonna have to apply the law to the facts. That's what you stood up and swore an oath to do. That's why we asked you guys, can you be fair to both sides? That means, can you come in and apply the law as read from the judge? We get a chance to read you that law as well, in PowerPoint or in person. And the judge is going to read you that law again. Can you be fair? Leave your passions at home. Leave your emotions at home. Everybody feels some kind of way about crime. Can you leave that at home and apply the law to the facts? The law guides you. You make decisions based on the law. That's why we have a scale of justice, not an emotion of justice. We have a scale. You have to do a balancing act. You have to leave what you might feel when you're at a family barbecue and you're talking about a case like this. Because let's just be real. We could be at a barbecue and say, you know what? Yep, I think that's exactly what happened. I think that's exactly what happened. You know that's what those people do. You know that's what these young people do. They get together and they go out here and they do this and they do that. I know it from my experience. What did the judge tell you guys a few days ago? What's in these four walls, right? Based on the law. It's not what you think. Mr. Trepanier put up in his PowerPoint, you are not to use conjecture at all. I assert to you that the only way to fill in the blanks for his lack of evidence against Mr. Tolbert is to speculate. And the definition of to speculate is to have a theory or conjecture based on a lack of firm evidence. He told you, you cannot use conjecture. Remember, you guys are the criminal justice system of this case. So do your job or never speak about the criminal justice system as being unfair, because you are the criminal justice system. They don't get convicted or acquitted unless each and every one of you say so. That's it. That's the system. So the judge is going to read you some of the law. And one of the laws he's going to read you is that evidence that merely places upon a defendant a grave suspicion of the crimes charged, or that merely raises a speculation about the defendant's guilt, is not sufficient to authorize a conviction. That means I got a nephew like that, and he went in the car like this. I know my nephew, and I know it. And I know that's what they did. And I know they talked about this. And I know he knew what was going on. You don't know. You don't know. There's been no evidence that you know. None whatsoever. You can speculate and get there. We can meet at a restaurant and we can talk about all sorts of different cases. And we can speculate. But in here, as the criminal justice system, before you vote, you got to have evidence. That's got to tip that scale. You don't have it. Let me clear one thing up. It's really not that important, but this cell phone that they say belonged to Mr. Williams, he had access to the phones. That's what the evidence was. Remember, the phone's in the car when the car gets stopped and he's not in the car. He's a homeless person. He says, if you want to reach me, there's a phone that people will answer, they can get a message to you. I just wanted to make that clear. I just wanted to be clear. It's not that it's going to change anything, but I just wanted to be clear. And there's another issue about the word access to the car. Does that mean I live in a house where the keys are, or I have permission to drive? I don't know what the answer to that is. The person that owned the car said he never drove my car. So in her words, he didn't have access to the car. You gotta reconcile that. I just wanted to point out those two things. You gotta reconcile that. The job you have to do, and before you cast your vote, is you have to determine whether there's reasonable doubt. And the judge is gonna read it to you. I'm sure the other defense counsel is gonna read it to you. Mr. Trepier might say it to you again. The crucial point in that is, this is what reasonable doubt is. If after considering all the evidence, your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law, and you must acquit. So that means is that if you have to fill in the blanks with more than just common sense, because you can use common sense to say, yep, I had a cousin who did something like that, and I know people, they do something like that, and I know people talk, and they talk to one another, and they reach an agreement. Yeah, you can believe that. Okay, you can believe that, but you're speculating to get there. That's how you get there, by speculating. So if you're wavering and you're saying, I'm not sure if Mr. Tolbert ever got out of the car and did anything. I'm not sure from the evidence that they presented any agreement between these two parties to do anything. I'm not sure from the evidence that they show where Mr. Tolbert intentionally helped the driver of that vehicle do anything. Then your mind's wavering, and the law says you must acquit. That's what the law says. That's what you agreed to. So it doesn't matter how you feel. I'm sorry to say it. It does not matter how you feel. That's what the criminal justice system is supposed to do. And that's who you are today. That's shocking. Okay. How do we know the decedent didn't see two people as he turned around in the car? Two people in the car. We know two people in the car. Okay. How do we know Mr. Tolbert ever got out of the car? How do we know what that statement means? How do we know? We don't know. How do we get there? We can speculate. We can sit around, we can flip hamburgers. Yeah, you know, I think they both got out of the car. Yep, that's what I think. Of course, that's reasonable to think that. It's not unreasonable to think that. Of course, yeah, why can't you think that? But that's circumstantial evidence that they're using here. And in order to use circumstantial evidence, it's another law of Judge Reach. You must exclude every reasonable theory consistent with innocence. If you cannot exclude every theory, you can't convict based on circumstantial evidence. So here's a theory. Car pulls up, mighty close. I'm assuming it's 3-something in the morning. If you're walking down the street at 3-something in the morning and a car comes to a stop, what are you gonna do? Most likely, you'll be like, oh shit, right? Excuse my language. You see two people, okay? Is it unreasonable that later on this person says, they shot me, I saw two people, but this person never gets out of the car? That's not unreasonable. And that's a reasonable theory consistent with he never intended to do anything and never intentionally assisted. That's reasonable. Let's go to Mr. Wiley. What did he see? I see two people struggling, right? Okay, what does he do? He turns around, right? Bam, gunshot. What does he see? The same person he saw struggling, waving him around. What evidence have they presented to you? The passenger did anything. So is it unreasonable that maybe the passenger did not participate, did not aid, did not assist? Well, again, if we just at the barbecue, half of us will say, yeah, I think he knew, I think he was doing something. That's fine. That's what you can do at the barbecue. We're in the court of law. So you've got to find evidence to tip the scales. That's what you have to do. State has 3 ways, 3 bites at the apple to try to convict my client. Number 1, he directly committed the crime. Okay, we don't have any evidence whatsoever. Then he's got 2 other ways: conspiracy, party to the crime. He read you the law on party to the crime. Everybody is just as responsible for anybody else if they directly commit the crime. That's the first prong. We don't have that. Intentionally helps another in the commission of the crime. So you have to go through this. It's part of your balance. You're doing more math than you are emoting in this case. More weights and balances in this situation. You have evidence that he directly committed the crime. Does not exist. It does not exist. Do you have evidence that he intentionally assisted in the commission of the crime? What evidence we have? A passenger. Somebody struggling. That's also the same person that's around here waving around. There's no evidence this person ever got out of the vehicle and ever did anything. No evidence. None whatsoever. None whatsoever. No evidence that he knew that Mr. Williams and Ms. LaFleur knew that Mr. Williams was a suspect in murder the very next day. No evidence whatsoever. None. Zero. How do you get into his head? Because he was in Chicago with Mr. Williams. So because he was in Chicago with Mr. Williams, they had a conversation about everything. They had a conversation that morning. Mr. Williams said, come on, jump with me. I'm going to rob somebody. And you can believe that. You can. You can believe that. You can. But you're speculating to believe that. Remember that. And if you base your decision based on speculation, then you've done your job, go home, be satisfied with the criminal justice system. You satisfy the people who use speculation, then go home, do your job. Other than that, you've got to apply the law to the fact. You've got to apply the evidence that we have in this case. That's essentially it. You have a job to do. It's more weights and balances than it is emotion. I assert that the evidence is not sufficient, absent your speculation that Mr. Williams intentionally aided in the commission of this crime or intentionally agreed with Mr. Williams to commit this crime or intentionally conspired to commit this crime. The judge is going to read you that mere presence and mere association is not sufficient to convict Mr. Tolbert. It's not. Oftentimes, people are there when a crime occurs, but they didn't know it was going on, didn't participate, didn't want to participate. They were just there with the person. They may have been around the person again at another time. That doesn't make that person guilty. What makes you guilty is your being complicit in it, intending that that's what happens. And they can only get there by evidence, not by your belief or speculation or conjecture. And that's it. We assert that the evidence is not sufficient. And we think the only verdict with respect to Mr. Tolbert is not guilty because he did not have the intent, aid, to assist, or to conspire with Mr. Williams. And that's based on the evidence. Thank you.
Thank you, Mr. Francis. Ms. Feely?
Before we go to the beginning, that when this trial was over, you still would not know what happened or who was involved. I told you at the beginning, the state's witnesses didn't witness anything. The medical examiner, the firearms expert, the detectives, great, excellent professionals, but they are not witnesses to what happened on January 14th, 2019. And not proven is not guilty. State's case is a mess. We don't know what happened. I don't even know for sure what their theory is, who they think the shooter is. But you can't convict two men beyond a reasonable doubt when it doesn't even seem clear that the state knows what happened. So I only get one chance to address you, the prosecution gets to go last, so I'm going to talk about the law. The most important concept for me to try to drill home is what beyond a reasonable doubt means in this courtroom, in courtrooms across the nation. It is a very specific standard. So when Detective Benton took out the warrant, she could believe and convince one person, judge, that there was probable cause that these two had committed a crime. That's what for arrest, but this is for conviction beyond a reasonable doubt. Because that judge didn't hear everything that you heard and the lack of what you heard. So when we're talking about, when you're back there talking about what beyond a reasonable doubt level of proof is, it's important that you realize what it is and what it's not. What it's not is even if you think you're gravely suspicious that Rommel was involved, that is not sufficient. You can be gravely suspicious, and that is not legally sufficient to warrant a conviction. So when you're back there, if you feel like maybe Rommel was involved, maybe Rommel was in the car, that is reasonable doubt. You can be back there and you can think probably Rommel was involved. He probably was involved if you believe that. I don't think the evidence supports it, but even if you get to, you believe he probably was involved, it would be your duty to acquit him because that is not proof beyond a reasonable doubt. So the state talked about circumstantial evidence. I'm going to do the same. Examples. The phone records, that's circumstantial evidence. That doesn't show that Rommel was there. It shows that the phone associated with him was there. That's circumstantial evidence. You know, an example of circumstantial evidence that we don't have here is we don't have a single person saying that they ever saw Rommel Williams with a gun. He's not. Nobody came in here and told you he's known to carry guns. They know he has a gun. Nothing. That still wouldn't prove that he shot anyone, but it would be circumstantial evidence of potential firearm possession. Not a single witness told me they saw Rommel Williams with a gun. Not that day, not ever. The state's resting on the phone records. And that is what they can do, but it's not sufficient to prove actual, one, being there, and then two, being involved in what happened, or being the one who did it, or knowing that the other person was going to do it. So I met a friend this morning to run, and we met at a MARTA station, and I left my phone in my car. We were gone for about an hour. If something had happened at that MARTA station, if there had been a shooting at that MARTA station during that hour, my car would have been pinging all over the place. The tag readers and my phone would have been there for an hour. Now, let's be honest, I would get the benefit of that doubt for unfair reasons that I don't need to explain to all of you. Some of you talked about it in jury selection. But if something happened at that MARTA station, people would be like, come on, your phone was there, your car was there. You must be the most unlucky person in the world. Fact is, this kind of stuff happens. Now, the state also, when they were talking with you about reasonable doubt, used the getting gas analogy. But when you get gas, you then turn your car on and get the direct evidence that your tank is full. And they also showed you a picture of a dollar bill to try to show you that you don't need that much proof. I mean, you can tell what it is. Sure, you can tell what it is with the pieces missing, but you can't tell what the state's hiding by leaving those pieces out. And you can't tell if that dollar bill is real or fake. Judge McBurney is going to give you a limiting instruction. You've already heard one. And because we stipulated that Ramel is a convicted felon. Please don't hold Ramel's past against him. That's part of what got us here. The conclusions that someone made because he has a record. You'll see the years. This was sometime in 2000, it's a 2009 case number. So 2009 or sometime before then. And then 2014, 14 case number. So we're talking 9 and 13 years ago. In Chicago, where he is from. That has nothing to do with the Ramel Williams of January 14th, 2019. He is so much more than his past and his criminal history. So the judge will give you a limiting instruction, and that's not a suggestion. It's the law. You can only use his record for the purpose that the judge will give you. So you can judge him, might ask you not to, but you cannot use that as a reason to convict him other than the limiting instruction for the limited purpose. The state is betting on people like you not caring about people like Ramel Williams. But you took an oath to do it, and I know that you will use that evidence only for the limited purpose that it's allowed for. This is the state's favorite jury charge. They've already discussed it. So the testimony of a single witness is sufficient to establish a fact, not it isn't enough to prove beyond a reasonable doubt anything. It is sufficient to establish a fact, provided you find it sufficient. So the state, it's not, if you believe Brian Wiley, there were 2 people in the car, there were 2 people in the car. You get to decide that. And you don't have to find that testimony sufficient. You also get to determine witness credibility. And the judge can instruct you that you can use the manner in which the witness testified, their means and opportunity of knowing the facts. You can go back and watch that video and see how much time Mr. Wiley actually could see inside the car. The nature of the facts about which they testified, the probability and improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility. So of course, we heard from Detective Benton. She's got an interest in the case. And you don't have to believe that Brian Wiley came in here intending to mislead you or be dishonest. This was 4.5 years ago. I feel for the guy. He told you he couldn't see inside the car the first couple of times. And then he says when the car drove by him on the right, that's when he says he saw 2 figures. He might have just been mistaken, or he might have forgotten. But that's not proof beyond a reasonable doubt there were 2 people in the car. So the state has a burden of proving identity at the same level as all the other elements. So that is beyond a reasonable doubt. We're going to talk about this a little bit later also, but Brian Wiley, the only eyewitness to this shooting, the only one, was given a six pictures, one of which was Ramel Williams. And not only did he look at those 6 pictures and say, no, I don't recognize anybody, he picked another one. He picked another person. So we know that he was simply not able to see And that's huge. Because if identity is not proven to you beyond a reasonable doubt, it is your duty to acquit. And the judge will instruct you on that. Intent is also a material element that must be proven beyond a reasonable doubt. So if you get all the way to, you believe beyond a reasonable doubt that Ramel was there, you then have to find beyond a reasonable doubt that he intended the shooting that occurred. Same with knowledge. If you get all the way, and I don't think the evidence supports it, but if you get all the way to believing Ramel Williams was there, knowledge is also an essential element that the state must prove beyond a reasonable doubt. This is so important. Knowingly and intentionally commit, participate, or help. There is no evidence of that here, and it is your duty to acquit. You cannot presume criminal intent. So, for consideration of words, conduct, demeanor, motive, and other circumstances. You can consider Ramel's behavior after it's happened, the day it happened. So sympathy is another jury charge. And it's not that we are asking you not to be sympathetic to Frank Fluid III's family. We're not. This was a senseless tragedy. And those autopsy pictures that you saw are heart-wrenching. We are in no way taking away from the senseless tragedy that his family suffered. But convicting Ramel Williams is not justice for Frank Fluid III. And you cannot base your verdict on the sympathy that we all feel for Mr. Fluid and his family. So this is the third bite of the apple that Mr. Francis was talking about. But there is no evidence here of an agreement between these two men. They would have to prove beyond a reasonable doubt that there was an agreement by these two for conspiracy to apply. Conduct before and after. So Ramel and Vanessa and Alicia are in the car together the same day this happens. Does that seem like somebody who knows that this car was just used in a crime? The judge is going to instruct you that if you believe Ramel was there beyond a reasonable doubt, his mere presence there is not enough. Must have committed, helped, participated in. Mere association with the person who committed the crime is insufficient to convict. The judge is going to instruct you that your verdict must be unanimous. And that's true. But you all don't have to agree on why the state's evidence is insufficient. So let's talk about all of the examples of reasonable doubt in this case. Number one, Frank Fluid III's cell phone. We know he had it because he's on video talking on it. We heard all kinds of cell phone records, all sorts of cell phone evidence. The technology is there. track his phone. Who would even be here? Where did his phone end up? That's huge. They're accusing Rommel and Mr. Tolbert of taking it in an armed robbery. So you literally just need the phone number, because you heard Rommel gave his phone number to Detective Benton and she tracked it. Track the phone. Detective Benton is one of the most experienced detectives in all of Atlanta police. That's what she testified to. But you can't track the phone. It's because it wouldn't have matched up with the other evidence. She thought this was going to be enough for you, that you wouldn't need to know where the backpack was, or where the phone was, even though the technology is there. Did it end up in the Center Hill house? That would have been huge. Or did it end up somewhere else? It wasn't in the car when it was pulled over. So speaking of phones, there are 2 phones in the center console when the car is pulled over, the day of this happened. So by the state's logic, those people should be charged too, because those phones were in there when this happened too. So this isn't like a theory that we're throwing out. This actually happened. There were other people's phones in that car. The detective told you that there was no call, no voice activity. There was just data usage, which is consistent with Rommel having left his phone in the car and it's not being used. Or it's not out of the question that Mr. Tolbert, when he got the keys, got Rommel's phone, because he's, as you heard, socioeconomically not able to have a phone all the time. So where is Jatasia Williams, whose phone was in this car? Any relation to Vanessa and Rommel? We don't know who she is. Who is Brandon Smith, whose phone was in that car? Wonder what he looks like. You heard a 911 call. It was the very first witness. You heard the 911 call. Who was that? Who is that person? That person didn't come and tell you what they saw. What did she see? That could have been one more witness to say, yes, there was one person or there were 2 people in the car. Where is she? This is a murder case. She was at the scene within moments. She very well could have witnessed something of evidentiary value, and you can kind of hear other folks talking in that 911 call too. So there are potential other witnesses as well. Detective Benton couldn't have gotten that number from 911 like she did the other one, vice versa. You get in contact, your contact at the 911 center and get that phone number to follow up with that 911 caller about what she saw. And the 911 caller also mentions being near a Chevron. We have all seen on the news gas station surveillance video. It is pretty good. Mightn't it have seen this car in a way that you could see whether there's 2 people? They didn't pull the Chevron footage, so we don't know. Another reason to doubt is the shakiness of the eyewitness testimony. You heard 3:30 in the morning, everyone agrees it's dark. Even the state wanted you to believe it was dark because they wanted you to believe that it wasn't unreasonable for Mr. Wiley to pick somebody else out of the lineup. But Sharita Thomas told you the trapper's windows were tinted. Mr. Wiley told you his windows were tinted. It's moments when that car passes in the intersection. It is unreasonable to believe that he saw 2 people clearly. He says he saw 2 figures. So again, another, well, and just eyewitness testimony in general. you get to be the judge of how much credit to give it. So let's talk about Romel's behavior. He doesn't know that this happened, so he doesn't have any qualms about being in this car the same day with his sister and girlfriend. This is not the behavior of three people who know that they're sitting in a car that was used in the murder. He is still in contact with his job. He tells everybody and their brother that he's going to Chicago. The state put funeral in quotation marks in their PowerPoint. Alicia told you it was Romel's auntie. And she explained to you why they couldn't come back. Because again, socioeconomic status, can't just rent a vehicle at the drop of a hat. And you also heard that Vanessa didn't have permission to use her vehicle, but did. So we're talking about access to a vehicle versus permission. But saying that you should be suspicious of Romel because he went to Chicago, but there wasn't evidence of a funeral, I don't think the state needs to be throwing stones about what evidence is lacking here. About what? You heard that they held his job open longer than they would be for another person that they normally do. What does that tell you? He was a good employee. But telling his employer is not consistent with somebody who's fleeing, a fugitive from justice, as the state wants you to believe. He spoke with Detective Benton the day this happened. And he doesn't impersonate Mr. Tolbert when he talks to her. And that's just part of, that's not something that is part of Romel Williams as well, is to offer up another man's name, especially when you don't even know what happened. You heard that that Romel spoke with Detective Benton from Chicago, called her from Chicago. The state is trying to convince you that Mr. Tolbert rode with Romel up there. But again, it's super easy, as we've seen, to track their phones. So why track the phones? See who got there when and if they were together. There's just no evidence that they traveled together. But calling a detective and telling her where you are is not fleeing. And it's certainly not evidence of knowledge of guilt. You heard the tag reader witness testify that the tag reader was reading all of the tags of passing cars. Just like they did for Alicia, run the tag and see who the owner is and talk to them, see what they saw. They were witnesses who could have, again, come in to tell you how many people they saw in the car and what else they saw. Another reason to doubt this case that's based so much on eyewitness testimony of Mr. Wiley, we know that eyewitness testimony is unreliable. And how do we know? Because Mr. Wiley said he knew for sure that that tracker that he saw did not have a spare tire. The state kept asking because that wasn't the answer they were looking for. And he said that I didn't see it. So much so that the state had to refresh his recollection by showing him the video. That's huge. He was mistaken about whether there was a spare tire or not. That's true for his entire testimony. And that's all we are basing that there were two people in the car on. Besides what's on. If you were back there wishing that you had video, that is reasonable doubt. Because we don't know what else Mr. Wiley remembered incorrectly and told you incorrectly. But there was video, and so we were able to correct his error of saying there wasn't a spare tire. We don't have the benefit of that here. We just have to rely on what he says. You heard that Alicia was pregnant in January of 2019. Their daughter's 4 now, but she was pregnant at the time and she was waking up a lot to use the restroom. She didn't say at 3:37, I know he was in bed, but she told you that her mom was there when she went to bed and when she woke up. It's unreasonable to think that he was out murdering somebody and then came back in time to take her to work. Another reason to doubt that we talked about, so I won't harp on it, but it is huge, is that lineup. The one eyewitness to this case was shown a lineup and picked another man. Yet the state wants you to convict this man of murder when nobody identified him. And Alicia, another reason to doubt is Alicia told you that Tolbert didn't have permission to drive the car, but he didn't need permission if she was asleep. He took it. Same thing. Another reason to doubt is the other adult living in the house that you heard about. Tolbert's girlfriend and Colin. Another adult in this house that the detective investigating a murder didn't talk to. Was it Tolbert and Nicole? The only person who said it was a male was what, Mr. Rockley? Who is she? What does she look like? Would Mr. Wiley have recognized her? Another reason to doubt, and we'll talk about if you believe beyond reasonable doubt that Ramel was there and that it was not just his phone, which is not supported by evidence. I think the evidence that his phone was there. But then where does that leave the state? Because again, they can't just rest on proving he was there, because you're going to get the mere presence jury charge. They have to do more than prove he was there, which they can't. But even if you find that they did, then now you've got mere association, mere presence. The state has to prove to you beyond a reasonable doubt that Ramel knew what was going on and helped somehow. These are not two men who are in good news. And even if you believe beyond a reasonable doubt that Ramel was in that car, which again, I don't think the evidence supports, but if you do, he's in the car with somebody who's armed now, who just shot someone. He's not helping, he's not involved. So if you believe that Ramel was there, you still don't know what happened. There was a knife at the scene. You heard the trajectory of the bullet was from somebody below, maybe on the ground after the struggle. We don't know. And that's a problem for the state. Because what was this, self-defense? There was a tussle and the other person fell on the ground and shot. We have no idea, and you can't even rule that out. You cannot even rule out that this, whoever did it was acting in self-defense at the time, because there's another weapon at the scene. And the medical examiner told you the trajectory of the bullet and where it was. So we know that Mr. Fluett had injuries consistent with a struggle of some kind. And we know for sure that that same day, Ramel Williams had no signs of a fight or a struggle. We know that because he saw the detective that day and spoke with her. We don't know that necessarily about anyone else, but we know that Ramel, there was no evidence that he had been involved in that fire. So another reason to doubt is Detective Benton. One of the most experienced detectives in all of APD was unable, in all of her expertise and experience and training, to get any physical evidence whatsoever tying Ramel to this scene. She has impressive credentials. She got the tag reader, she got the cell phone records, but even she couldn't find any physical evidence to tie Ramel to this murder. She got a search warrant for the car. She never got a search warrant for the house. Never tracked Mr. Fouette's phone. But she thought she had the car, she had the phone records, that would be enough. Another reason to doubt, where is the backpack? This is all the state has to prove that something was taken. Where is the backpack? What was in the backpack? The most important reason to doubt is in this shooting murder case. The state didn't bring a gun. The state already said once, and they're gonna say it a million times, I'm sure, that it doesn't matter that we don't have a firearm. That's what they said. But guess what? You get to decide whether it matters. The state's opinion on whether it matters, that in this 10-count indictment, where every single count requires them to prove the existence of a handgun, an element of every single one. Handgun, firearm, handgun. They want you to convict Ramel Williams of these extremely, you don't get much more serious than this. And they didn't bring you a firearm or bring a witness who said they saw Ramel with a firearm or he's known to carry a gun, anything like that. If they had searched the house, would they have found a firearm? We don't know. And if they had found a firearm, whose fingerprints were on, whose DNA was on, all of these things, you don't have to find this acceptable because it's not. The Sacker told you that if the DA's office or Atlanta police had found the gun yesterday, she could have done the same test to see if it was the one who fired the shots. This isn't something that expires. No evidence, no effort at all to get evidence in this case because they hope you would rubber stamp it. You're back there wondering about that firearm, as you should be. That is reasonable doubt, and it would be your duty to. Judge is going to instruct you that you're not to concern yourself with sentencing, and that's true. If you convict Ramel Williams based on this evidence, you're done. Enjoy the rest of your day. You don't have any say in that part. And again, I can't, without sounding like a broken record, I cannot emphasize enough how high the standard this is. And that if you find yourself saying, yeah, he probably did it, that is reasonable doubt. Don't let the state minimize the burden. They told you not to go looking for doubt. Well, it kind of finds you in this case, but I don't know that instruction. Something that necessarily appropriate. If you are back there wishing there was more more video, something, anything, tying Ramel to Frank Fluette III, there's been no established connection there. Be critical of the state's case. If you are back there saying, I wish there was a video, I wish there was a gun that we could have gotten, I wish there was DNA, fingerprints, something, any of those, just something else. Look no further than the table of the state of Georgia, whose burden of proof it is to prove this case. The lack of detective work unfortunately works against you now. It's a problem created by the state, but it's a problem for Ramel because you've seen all the evidence. And if you convict him based on this evidence that you've seen, there is nothing else. There is no DNA to test later to exonerate him. This is it. So I'm going to sit down and immediately think of 10 things I should have said. And you've seen me checking my notes. And that's because I'm scared. But I haven't done enough to help you see the holes in the lack of evidence and the truth about this case. But I know, remember, I saw you taking notes. So when I sit down, I'm giving it to you. And I know after this is over, you'll remember this experience, this jury experience for a little while. Maybe tell your friends and family about it. The lawyers will remember it for a little longer because we've worked on it more than this week. Ramel Williams is going to remember this day for the rest of his life. Because what happens today alters the rest of his life. Whether you make him a convicted murderer based on this, or whether you see the reasonable doubt all over the place. If your minds are wavering, unsettled, or unsatisfied, which they very well should be, then you have to return the only verdict that the evidence supports. And remember, convicting Ramel is not justice for Frank Fluette III. So return with the verdict, the only verdict that evidence supports, and that is not guilty on all counts.
Thank you, Ms. Feely. So, Mr. Trepanier, here's where we are. We've got about 30 minutes, and you have more than 30 minutes. I don't want to limit you in any way. Do you think your rebuttal, you can fit in that window? What I don't want to do is interrupt you and say, uh-oh, my meeting's starting, so then you're going to come back after lunch with a few more minutes.
I think, Judge, that I can do my rebuttal within that time frame.
Okay, then let's do it.
Your Honor, can I have a brief?
You sure can. I'm sorry. I didn't mean to ignore you all. We've been going for about 1:40. I thought we'd wrap it all up, but let's make it super brief so we can, you take the time you need, but if the break takes too long, then we're going to have to finish closings after lunch because I can't budge my thing. So if you need to use the restroom, follow this gentleman, and otherwise, please stay here. Okay. All right, we've got everyone back. Mr. Trepanier, when you're ready.
Frank Fluid III doesn't get to be here today because of what these defendants did. Want to talk about the firearm in the back. Because a defendant shouldn't get a pass just because maybe they got rid of a firearm, or maybe they got rid of a bag. That's not what this is. What's interesting is that defense counsel indicated all of these questions that she could have asked Detective Fenn. Why didn't you get a search warrant for us? Why didn't you do this? I submit to you the answer to that is because maybe the answer would not have been good. Because the answer would not have supported their theory. So what do we know? What do we know? Mr. Tolbert admitted he was there. Mr. Tolbert's fingerprint is on the passenger side of the vehicle. Okay. That leaves the driver. Serena Williams. We know that there were only 3 people in the house that night that could have had access to that vehicle. You heard that Detective Benton said that Mr. Williams himself said that. Alicia LaFleur, same thing. It was Anthony Tolbert or Alicia LaFleur. We know that Mr. Williams and Mr. Tolbert were in Chicago together. Mr. Williams was maybe there for a funeral. What reason was Mr. Tolbert there? What does that show? Conduct and presence of parties to show conspiracy. Add that to all of the other evidence, the cell phone records, the testament. These things aren't a snapshot. You don't just consider one thing, consider it all together. We know that Mr. Tolbert didn't call 911. Mr. Tolbert said he was there. there's no way that Mr. Tolbert didn't see or hear a struggle and hear gunshots. Mr. Tolbert didn't call 911, we know that. Because we know that the only two things associated with this, the CAD reports, are the shot spotter and the 911 call from that bystander. Mr. Tolbert didn't assist. Why is he in Chicago? And let's go back to what Mr. Renaud Williams said. Told Detective Benton, when she started confronting him about who had access to the vehicle. Oh, maybe the car must have been hot wired, right? The car must have been stolen. Okay. But what we know is that the vehicle was there that morning so that Alicia LaFleur could go to work. We know that the driver of the vehicle never had to stop. We know Mr. Tolbert's hands on the passenger side. We know the driver could have controlled this whole situation. Because it's the driver who made the U-turn. It's the driver who stopped, followed Mr. Fluid. It's the driver who pulled into that little driveway. It's the driver who pulled up and again stopped behind where that utility pole was. It's the driver who did all of it. Only 3 people had access. Mr. Tolbert was on the passenger side. Again, we know that there are 2 people in the vehicle. How do we know that? Mr. Wiley said so. And his statements are consistent with the other evidence. The cell phone records, the 911 call, the they. We know that there's more than just one person involved. And one of the things that come up is who fired him? Who actually fired the shot? Who actually fired the shot? It doesn't matter. Because as we talked about, it's parties to a crime conspiracy. Mr. Tolbert and Mr. Williams are on the hook for what each of their actions was. Because they're acting together. Use your common sense. Use your common sense. Common sense says, if you find out that your vehicle has been used in a murder, the vehicle that you're in a traffic stop with, and you say you know nothing about it to the detective, but then when you talk to your girlfriend, you say, well, maybe the car was there because I drove by later after I dropped you off. Use your common sense. Let's look at those 2 things. They don't make sense together. What else do we know? Miss Feely gave this example of going for a run and leaving her cell phone in the car. What she left out saying about that example was that other person that she was with could have said, no, I was with Miss Feely this whole time. Again, what is this case? This case is that Mr. Frank Flew III was walking alone at 3:30 a.m. And that these 2 defendants were in Miss Alicia LaFleur's vehicle. They were driving, they saw him, they made a U-turn. Mr. Frank Flew III was robbed of his book bag and he was shot. Armed robbery, aggravated assault. Felony murder, murder. possession of a firearm during commission of a felony, possession of a firearm during. Second. We know that that vehicle went back towards the 874 address, the home. And when Miss LaFleur woke up, everything seemed to be normal. Okay, so we know that that vehicle got back there. This wasn't a situation of this vehicle just being out everywhere during this period of time. It travels from west to east. It's at the crime scene. It travels north just a little bit, like it shows on the big video, and then it heads back to that location where Mr. Ramel Williams and Anthony Tolbert stay. Mr. Floyd, the only three people who have access to that vehicle. And again, use your common sense. If this is Mr. Tolbert acting alone, why would he be making sure to get this vehicle back right on time for Ms. LaFleur? Because we know from Ms. LaFleur herself that one, she didn't let him use the vehicle, she didn't let him drive the vehicle, and two, they clearly did not have a good relationship. Yeah, nothing good happens after midnight. This is a case of predators and prey. These two individuals took advantage of that situation. They committed that armed robbery, that aggravated assault, committed that murder, and Mr. Frank Fluke III is not done. I'm going to ask you to return a verdict of guilty. You're going to consider each of Mr. Williams and Mr. Tolbert. I'm going to ask that you return a verdict guilty on all counts as it relates to Mr. Tolbert and Mr.
Thank you, Mr. Trepanier. All right, ladies and gentlemen, we have completed the closing arguments. All that is left is the charge that I will give you after lunch. It's not the optimal time for the charge because the charge isn't real exhilarating. There's no video. You don't get to really like handle evidence, and you'll have just eaten. So eat a light lunch or a lunch real high in sugar, so you're still on the sugar high when I give you the jury charge. Let's try to be back at 1. That's a little bit more than an hour. I'm going to try to extract myself from my meeting at 1, and I will deliver the charge to you all. After that, you'll begin your deliberation. So that means that during lunch, should you eat as a group or subsets, don't talk about the case. You've heard everything you're going to hear from the lawyers. You got all the evidence as of yesterday. But you still don't have that law that you need to figure out, well, wait a minute, is this proof beyond a reasonable doubt or not? I don't know what needs to be proven for murder or aggravated assault. I'll be telling you about that after lunch, and then you will be in a position to begin your deliberations. Any logistical questions? Have a great lunch, and we will see you as close to 1 as we can make it happen. You all should be seated. I need to cover one jury charge situation with you. Isn't it? Very good. All right, I'll get you wow, that's life size. Thank you. Great jury. I will get you all a hard copy of the final charge, but I have 2 things I want to discuss. One is whether we still ought to give corroboration required for accomplice testimony because we didn't have accomplice testimony. I think that should come out because unless they think Mr. Wiley was an accomplice, there wasn't any. Do you agree, Mr. Trepanier?
Agreed.
Ms. Feely? And Mr. Francis? All right, I'll take that out. And then the other, I wanted you all to look at what's on the screen, the limited use of certain evidence. That first paragraph is unchanged from what was in there. It says, you've received evidence that Mr. Williams has some convictions, and that's only to be used for purposes of showing if it does that element of conviction of a felony and for no other use against either Williams or Tolbert. That was in there before. I added the next two sentences, and that is my distillation of the limiting instruction in connection with testimony that Benton gave about what Tolbert said to her during his custodial interview. I'll read it into the record in case it's too small on your screen. You have also received evidence of statements defendant Tolbert made to law enforcement. That evidence may only be used against defendant Tolbert. Mr. Trepanier, any issue with those two sentences?
No, Judge.
Ms. Feely?
There.
Mr. Francis? Okay, I'll take away the highlight on that title. I'll take out the corroboration of accomplice testimony and get you all a hard copy when I return from our break. Mr. Trepanier, anything else?
Just, I believe that under that limited use, it should be as to counts 4, 5, 9, and 10.
So you all said that, and it says it down when it's talking about it, but you have to prove 9 and 10. If you prove 9 and 10, that's part of 4 and 5. I mean, I'll put that in there. I don't disagree with it, but it's technically, it's proof of 9 and 10. 4 and 5, you have to have proven that offense. And so if they,
I think as the element of that offense, so that one particular element, I think is why.
okay, I don't disagree with you. I'll put in, it'll just be like it is with the stipulation you all entered that is referenced in the language concerning possession of a firearm by a convicted felon. They'll be that. Okay. Ms. Feely, any issue with that? There you go. All right, Mr. Francis, you okay with that?
Yes, sir.
All right, Mr. Trepanier, anything else about anything before we take a break?
No, Judge.
All right, Ms. Feely, anything else? And Mr. Francis?
No.
Great, if you all could be here at 1, I will try to extract myself from the bench meeting a little early and get going with the jury charge. Thank you.
She got it. I heard that. Yes.
All right, Ms. Rivers, are you ready? Okay, we're back on the record in State versus Tolbert and Williams. Alas, a little later than I had hoped. So much for the short bench meeting. We've got prosecutors here. Mr. Williams is here with his pair of lawyers. Mr. Tolbert is here with his lawyer. And I think we're ready for the jury and the final jury charge. Mr. Trepanier, anything we need to discuss before the jurors come out?
Nothing from the state, Judge.
I should have asked this. Maybe you've already done it because I see the magic former Coke bottle bin. Did you confer with the defense attorneys to see which exhibits go out with the jury and which don't?
We did.
Okay.
Conferred with Ms. Feely and Mr. Francis.
And were there any concerns from the state side as to what goes out and what doesn't?
Not from the state.
Okay. Ms. Feely, any questions or concerns about what goes out with the jury?
So it's our position that 97, the cell phone demonstrative should not go back. And then states 112 and 113 are the convictions. And so we pulled those up to not go back as well.
Okay, but you got no pushback from Mr. Trepanier. Okay. Mr. Francis, anything you want to add?
No, nothing to add, Your Honor.
Those three should not go out. Okay. Certainly the convictions, I've had debates back and forth about demonstratives, but if everyone agrees that that doesn't go back, if the jurors ask about it, it could be that they can see the demonstrative, but out here. But we'll leave it as is. I'm going to print out the verdict forms right now. I forgot to do that before. So you can eyeball them now. Prosecution. Thanks. Mr. Trepanier, the verdict forms are heading your way. If you'd give them a look over and then send them to Ms. Feely, she can send them around. Just need to make sure they are unremarkable in my mind, but I want to make sure I didn't miss anything.
They'll find the state judge.
Ms. Feely, any issue with Mr. Williams's verdict form? Mr. Francis,
No
we okay with Mr. Tolbert's verdict form?
Yes.
Okay, great. Let's bring the jurors out, please.
All right, judge. President, the count of four.
Thank you, Deputy Gordon. Everyone else can be seated. Welcome back from lunch. It's good to see you all. We are at the point now where I'm going to give you we call it the charge. It's also known as the law that you must apply to the facts as you find them to be. A little bit about format. I'm going to be reading to you from this document. This is the jury charge. It's a collection of principles of law and a couple of procedural points about how you conduct yourselves as jurors that I'm required to give you all. Some of the concepts I am required by higher court opinions to describe in ways that may seem stilted or awkward to you, and I apologize in advance. I'm not trying to impress you with big words or fancy phrases. That's not the way I do things. But for example, you're going to hear the phrase abandoned and malignant heart. That's not how I talk to my kids. It's not how I talk to my wife. But that's the way something is defined when it comes to murder. So you're going to hear that phrase. Good news is this document from which I'm reading will be yours to reread should you want to do that during your deliberation. So this, along with these verdict forms, which I'll talk about in a little bit, and the indictment, they're all going out in that little black basket along with all the physical evidence. So that little earring that you saw someone hold up and documents, they're all in there. This will go with it. So you're welcome to take notes, not a problem, but don't panic if you're like, I don't even know how to spell malignant. If it's important how to spell it, it's in this document. Second, for people who like to watch while they listen, or maybe not even listen at all, on the screens will be what I'm reading. There's not a bouncing ball that goes along as I talk, but the words of what I'm reading will also be on the screen. So you're welcome to watch if you'd like to do that. But I just want to reemphasize, this document will be with you during your deliberations. That I need to change. There we go. A grand jury has indicted the defendants for murder, felony murder, armed robbery, aggravated assault, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon. Doesn't say that in there, but counts 9 and 10, which we've talked about, are possession of a firearm by a convicted felon. Oh, it's right there. Defendant Williams has also been indicted for possession of a firearm by a convicted felon. So both defendants have those first charges. We've got Mr. Williams with the possession of a firearm by a convicted felon. And as I said, you'll have the indictment so you can match up charges and people during your deliberations. The defendants have entered a plea of not guilty to all these charges. Neither the indictment nor the pleas of not guilty are evidence. The defendants are presumed innocent. This presumption remains with them unless it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that one or both defendants are guilty of one or more of the crimes charged. The state must prove beyond a reasonable doubt every material allegation of the indictment and every element of the crime charged. I'll be telling you what those elements are in a little bit. There is no burden of proof upon the defendants, and the burden never shifts to them. If a defense is raised by the evidence, the burden is on the state to negate or disprove that defense beyond a reasonable doubt. The state is not, however, required to prove the defendant's guilt beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says, a doubt based upon common sense and reason. It's the doubt of a fair-minded, impartial juror who is honestly seeking the truth. It does not mean a vague or arbitrary doubt, but is rather a doubt for which a reason can be given. A reason arising from your consideration of the evidence, lack of evidence, or conflict in the evidence. If, after considering the evidence, your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law and you must acquit. But if such doubt does not exist as to the defendant's guilt, you would be authorized to convict. Evidence that merely places upon a defendant grave suspicion of the crimes charged or that merely raises a speculation about a defendant's guilt is not sufficient to authorize a conviction. It is my responsibility to instruct you on the law. That's what we're doing right now. You are bound by these instructions. It is your responsibility to determine the facts from the evidence presented. You must then apply the law I am giving you to the facts you find. You must decide this case based only on the evidence presented during trial. That evidence consists of testimony and exhibits. Evidence does not include the indictment or pleas of not guilty, anything I've said or the lawyers have said, to include their opening and closing remarks, nor does evidence include any questions posed. Evidence may be direct, circumstantial, or both. An example of direct evidence is the testimony of a person who asserts that she has actual knowledge of a fact, such as an eyewitness. I saw that the light was red when the car entered the intersection. Circumstantial evidence is proof of one or more facts that tend to prove or disprove some other fact by inference. There is no legal difference in the weight you may give to direct or circumstantial evidence. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. However, you may only convict if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the defendant's guilt beyond a reasonable doubt. You must determine the credibility or believability of the witnesses. In deciding this, you may consider the evidence, the witnesses' manner of testifying, their basis for knowing the things about which they testified, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their possible bias for or against a party. The credibility of a witness may be attacked by disproving facts to which the witness testified. You may also consider other evidence offered to attack the credibility of witnesses, including evidence of a witness's bias for or against a party. If a witness's credibility has been attacked, you may consider evidence offered to support the credibility of that witness. Your assessment of a witness's credibility may also be affected by comparing that witness's testimony to statements that he or she made before trial. You must decide whether there is a reasonable explanation for any inconsistency between a witness's pretrial statements and trial testimony. You have heard from witnesses who were designated as experts. Experts are those who, because of their training and experience, possess knowledge in a particular field that is typically not known to the average person. Experts are permitted to give their opinions based upon that training and experience. Testimony of an expert, like that of all witnesses, should be given only the weight and credit you believe it should receive. The testimony of a single witness is sufficient to establish a fact. Corroboration of a witness is not required, provided you find the witness's testimony to be sufficient. Defendants who have no burden to prove anything are not obligated to testify. When, as here, a defendant chooses not to testify, you may not consider that decision in any way in reaching your verdict. There are two limitations on the evidence that you've received. First, you have received evidence of prior convictions of defendant Williams. You may consider this evidence only insofar as it supports the required element of conviction of a felony for the offense of possession of a firearm by a convicted felon, as that is charged indirectly in counts 4 and 5 and directly in counts 9 and 10. You may not consider that conviction evidence for any other purpose, either against defendant Williams or defendant Tolbert. Number two, you have received evidence of statements that defendant Tolbert made to law enforcement. That evidence may only be used against defendant Tolbert. The state must prove the identity of the person or persons who committed the crimes charged beyond a reasonable doubt. A defendant does not need to show that some other person committed the alleged crimes. You have received fingerprint comparison evidence. Identification by fingerprint comparison is opinion evidence and is dependent upon the credibility and accuracy of the expert witness called for that purpose. Fingerprint evidence is governed by the rules on circumstantial evidence. If you believe that fingerprints corresponding to a defendant were found and identified, their evidentiary value, if any, would be diminished to the extent that they could reasonably have been impressed, placed upon, at a time or under circumstances that would be consistent with innocence. A verdict of guilty may not rest upon fingerprint identification alone unless you are satisfied beyond a reasonable doubt that fingerprints left by the defendant were found and that they could only have been impressed by the defendant on the vehicle in question at the time of the commission of the crime. A crime occurs when the law is violated by a defendant's intentional action. Criminal cases must be tried in the county in which the crimes were committed. This question of venue, that is, were the alleged crimes committed here in Fulton County, must be proved by the state beyond a reasonable doubt. Intent is an essential element of every crime. Criminal intent is not the intent to violate the law, but means simply the intent to do the thing that is illegal. Intent may be inferred from the evidence. It may also be inferred when it is the natural and necessary consequence of an act. A defendant is not presumed to have acted with criminal intent, but you may find such intent, or the absence of it, from consideration of words, conduct, demeanor, motive, or other circumstances connected with the acts for which these defendants are being prosecuted. This is a busy slide. Knowledge on the part of the defendant that the crimes charged were being committed and that the defendant knowingly and intentionally participated in or helped in the commission of such crimes must be proved by the state beyond a reasonable doubt. If you find that a defendant had no knowledge that a crime was being committed, or that he did not knowingly and intentionally commit, participate, or help in the commission of the alleged offenses, then it would be your duty to acquit that defendant. On the other hand, should you find beyond a reasonable doubt that a defendant had knowledge that the crimes charged were being committed and that he knowingly and intentionally participated or helped in the commission of them, then you would be authorized to convict. We're halfway through. You may not find a defendant who was merely present at the scene of a crime at the time of its commission guilty of that crime unless the evidence shows, beyond a reasonable doubt, that the defendant committed the crime, helped in its perpetration, or otherwise participated in the criminal endeavor. You also may not find a defendant who was merely associated with other people involved in the commission of a crime, guilty of that crime, unless the evidence shows, beyond a reasonable doubt, that the defendant helped in the perpetration of the crime or participated in the criminal endeavor. Every party to a crime may be charged with and convicted of commission of that crime. A person is a party to a crime if he, 1, directly commits the crime, or 2, intentionally helps in the commission of the crime. A conspiracy is an agreement between 2 or more people to do an unlawful act. The existence of a conspiracy may be established by proof of conduct, as well as by proof of some express agreement. When people conspire, any act done by one conspirator to further the conspiracy is considered to be the act of all conspirators. However, each person is responsible for the acts of others only insofar as those acts are done to further the conspiracy. Presence, companionship, and conduct before and after the commission of the alleged crimes may be considered in determining whether such circumstances give rise to an inference of the existence of a conspiracy. All right, now we get into the substantive charges that are in the indictment. For murder, the state must prove that a defendant, 1, caused the death of another person, 2, unlawfully, and 3, with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, doesn't necessarily mean ill will or hatred. Rather, it is simply the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another. You may also find malice when there does not appear to be any significant provocation and the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, that is, with unlawful intent, it is murder, regardless of how briefly that malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act that killed, and it moved him to do it, that is enough for the killing to be murder. Proof of motive is not essential to the crime of murder. Evidence of motive, if any, has been admitted for you to determine whether it establishes a defendant's state of mind at the time of the killing. Felony murder. For felony murder, the state must prove that a defendant, 1, caused the death of another person, 2, by committing a felony. The state does not have to show that a defendant acted with malice, i.e. intended to kill unlawfully, to prove felony murder. Armed robbery, aggravated assault, and possession of a firearm by a convicted felon are all felonies. You may find a defendant guilty of felony murder if you believe that he caused the death of another by committing the felony of armed robbery, aggravated assault, or possession of a firearm by a convicted felon, regardless of whether he intended the death to occur. However, there must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. For armed robbery, the state must prove that a defendant, 1, took another person's property, 2, from the other person or from the immediate presence of the other person, 3, by using an offensive weapon, 4, with the intent to commit theft. An offensive weapon is any object that is likely to cause death or serious bodily injury if used against someone. A person commits an assault when he attempts to commit a violent injury to another. A person commits aggravated assault when he assaults another with a deadly weapon. A firearm is a deadly weapon. A person commits the offense of possession of a firearm during the commission of a felony when he possesses a firearm during the commission of a felony. Murder, felony murder, armed robbery, and aggravated assault are all felonies, and firearm includes any handgun. A person commits the offense of possession of a firearm by a convicted felon when he possesses a firearm after having been convicted of certain felonies. Firearm includes any handgun. And I'll remind you that the parties have stipulated that the defendant, meaning defendant Williams, is a convicted felon for purposes of counts 4, 5, 9, and 10. You should consider each count individually against each defendant. The possible guilt of one defendant does not necessarily mean the other defendant is guilty. The defendants may be found guilty of some, all, or none of the charges. If, after considering the evidence together with this charge, you should unanimously find beyond a reasonable doubt that one of the defendants did commit in Fulton County any of the crimes alleged in the indictment, you would be authorized to find him guilty. In that event, the form of your verdict for that defendant would be, we, the jury, find the defendant guilty. And what you won't do is write the word guilty in. The way this verdict form works, there's one for each defendant because you consider them separately, and each verdict form has only the counts that are brought against that defendant. So I'm holding defendant Tolbert's verdict form. Count 1, murder. We find the defendant, and there's a blank, and it says guilty, and there's a blank, and it says not guilty. If, after considering all the evidence, you find that the state has proven beyond a reasonable doubt murder as to defendant Tolbert, the form of your verdict would be, we, the jury, find the defendant guilty, and you would check guilty. If you do not believe that a defendant is guilty of a particular offense, or if you have any reasonable doubt as to his guilt, then it would be your duty to acquit him, in which event the form of your verdict for that defendant for that crime would be, we, the jury, find the defendant not guilty. And you wouldn't write the words not guilty. You would check not guilty instead of guilty for that offense for that defendant. Whatever your verdict is for a particular count for a particular defendant, it must be unanimous. And your verdict must be in writing. That would be using these 2 verdict forms, signed by your foreperson, and dated. By no ruling or comment that I have made during the trial have I intended to express any opinion about the credibility of witnesses, the evidence, or the possible guilt of the defendants. Your verdict must be based solely upon your consideration of the evidence, according to the laws I've given you in this charge. It is your duty to consider the facts objectively, without favor, affection, or sympathy for anyone. It is also your duty to report to me if you perceive that someone in your group is making decisions based on improper considerations of race, gender, religion, or sexual orientation. Ladies and gentlemen, you are the fact finders in this case. You are not to concern yourself with punishment. That is a role for the judge. One of your first jobs in the jury room, to which you will retire very shortly, will be to select a foreperson who will preside over your deliberations and who will sign the verdict form to which all of you freely and voluntarily agree. You should start your deliberations with an open mind, consult with one another, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion of the case with your fellow jurors and a careful consideration of the evidence. During your deliberations, you must not communicate with anyone outside your group about this case, nor may you conduct any research. That's not news to you. You have all the evidence in this case. It would be improper to supplement it with any outside information. And to assist you in complying with these instructions, Deputy Gordon will be collecting all of your electronic devices, including Apple Watches if you have one, while you deliberate. I promise we'll give them back, but while you were back there deliberating, those devices will be making beeps and squawks in my chambers, and they don't come back until either you're done for the day, if you don't finish today, or you finish today. I promise we'll return them, but they are not back there with you while you're deliberating. Going forward, should you need to communicate with me for any reason, it needs to be in writing. Upon receipt of your question or note, I will confer with the lawyers and the defendants and share with you whatever response I am allowed by law to give. And that last little clause is in there for a reason. You may have a great question and I may really want to answer it, but the law may say that's something the jurors just need to figure out. And so sometimes my note back to you may be, you just have to rely on your recollection. If you ask for a transcript of a witness's testimony, I will likely write back, you have to rely on your recollection. But I gave you fair warning at the beginning of the trial that you wouldn't get transcripts of witnesses' testimony. But if you have a question or concern, no matter what it is, write it down. Deputy Gordon will get it. I'll look at it. I'll share it with the parties, and then I'll give you whatever answer I am allowed to under the constraints under which I labor. And with that, I have given you the charge. This document will go back with you along with the 2 verdict forms and the indictment and everything else. I will ask you now to retire to the jury room. You can take your notepads with you. You are free to consult your notes. You're free to share your notes now as you are working with your colleagues to sort through what the outcome here ought to be. If someone takes a break, you all take a break. There's no deliberating with 11 or 10. So if you've been deliberating for an hour and someone says, I got to go get a snack. First of all, we've got plenty of snacks for you, but you got to go get a soda. That's fine. Don't deliberate with 11 in the room. If you're the one going to get a soda, take orders from other people, get their sodas and bring them back. Breaking is fine, but that's a break for everyone, not just the person who steps outside. Okay? If you'll go with Deputy Gordon, we'll get the evidence to you in just a moment.
All right, we'll do it.
This. Thank you. Mr. Trepanier, anything before we take a break while the jury deliberates?
Nothing from the state, Your Honor.
Ms. Feely?
You just have to renew our objection to the conspiracy charge for the record.
Thank you. That is renewed. Mr. Francis?
Same objection, Your Honor.
Same renewal?
Same.
Got it.
Do you send out a copy of the charge?
I do. I told them that.
Okay.
I told you that. And it's actually right there in the box. And if they want more, we'll make more copies every once in a while. That's the question is, could we have 6 copies of reasonable doubt or something? I'll give them as many as they need. But there is what I just read is now sitting in that little box. So they'll definitely have it. Okay, so both defendants, Williams and Tolbert, have renewed their objection to the inclusion of the conspiracy charge. It is, I'm gonna call it 2:00. The jury will begin its deliberations. Alas, we have no alternates to send to our hurricane protection room. So let's hope these 12 bear with us. I need one phone number from each of the 3 sides on a note card or something, so we can get you back in here if you're not staying in here. If you're not staying in here, please stay in the building. Going back to your office or your home, not good.
I'm just verifying that the 97 is on the book.
And Mr. Williams and Mr. Tolbert, you guys will be brought out here for any question. If they have a question, you're out here to hear what it is and confer with your lawyer about what the answer should be. Don't think we're going to forget about you. Yes, Mr. Tolbert.
Hey, Mr. McBurney, can I ask you a question about the situation that happened yesterday? I'm just trying to, I wanna, we are on different floors at this point.
So let's do this. Pause. Yes, we can do that. I'm gonna have other folks. We'll have Mr. Williams go back, and then you and we don't have to close out the courtroom this time. I'm gonna mute our overall feed, and then you and Mr. Francis and I can talk about it. Okay. So just take a seat. All right. Deputy Gordon tells me that there is a verdict. Mr. Trepanier, anything we need to talk about before we bring the defendants in?
There you go.
Ms. Feely? Mr. Francis? All right, if we could bring Mr. Williams and Mr. Tolbert in, please. Got everyone. Okay. Ms. Feely, we ready for the jury?
Yes.
Mr. Francis?
Yes, sir.
Okay, let's bring the jurors in, please. Can I give you the one juror question? So Mr. Peck will be here next week for the remainder of his competency evaluation. There were problems doing it at the jail. So on Thursday, he'll be here. You don't have to, Ms. Green arranges all that and we need some kind of deputy coverage, but he'll be brought over and the doctor will come.
Okay.
I'll let you know whether it's morning or afternoon, but Ms. Green is managing that. Oh, you got the email already. I didn't realize you were on it. Sorry. You could have told me you knew.
You might have sent
Had
something.
new info.
Yes.
All rise on jury. You as the president accounted for?
Thank you, Deputy Gordon. Everyone else should be seated, please. Sir, it's my understanding you're the foreperson?
Yes, sir.
Have you and your colleagues reached verdicts in the two cases?
Yes, sir.
And were those unanimous verdicts in both those cases?
It was, yes.
And have you, on behalf of your colleagues and as the foreperson, completed the verdict forms as to each defendant?
Yes, sir.
Okay, if you'd hand them to Deputy Gordon so I can check them as to form, please. Sir. Sir, I'm going to ask you to stand now and publish the verdicts. And by that, I simply mean if you'd indicate for each defendant what your jury's verdict was as to each of the counts for that defendant. You can go in whatever order you want.
This is for Romel Williams. Count 1, for murder, we find the defendant guilty. Count 2, felony murder, armed robbery, we find the defendant guilty. Count 3, felony murder, aggravated assault, we find the defendant guilty. Count 4, felony murder, firearm by felony count, we find the defendant guilty. Count 5, felony murder, firearm by felony count, we find the defendant guilty. Count 6, armed robbery, we find the defendant guilty. Count 7, aggravated assault, we find the defendant guilty. Count 8, possession of a firearm during a felony, we find the defendant guilty. Count 9, possession of a firearm by convicted felon, we find the defendant guilty. Count 10, possession of a firearm by convicted felony, we find the defendant guilty. So say this on the 20th day of July.
Thank you, sir. And as for the other verdict,
And Anthony Tolbert, count 1, murder, we find the defendant not guilty. Count 2, felony murder, armed robbery, we find the defendant not guilty. Count 3, felony murder, aggravated assault, we find the defendant not guilty. Count 6, armed robbery, we find the defendant not guilty. Count 7, aggravated assault, we find the defendant not guilty. And count 8, possession of a firearm during felony, we find the defendant not guilty. So say we all this 20th day of July.
thank you, sir. Deputy Gordon, if you would please share the verdict form with Mr. Trepanier, and then if you'd pass it along, Mr. Trepanier. Mr. Trepanier, any objection to the form of the verdicts?
No, Your Honor.
Ms. Feely and Mr. Francis. Mr. Trepanier, anything else we need to cover from the state before I release this jury?
No, Your Honor.
Ms. Feely?
I was asked to pull them.
Okay. And Mr. Francis?
No, Your Honor.
Okay. Ladies and gentlemen, I'm going to ask each of you the same 3 questions as to your verdict in the case of State versus Romel Williams. When I call your name, please let me know your answers to these questions. We'll go in numerical order. Juror 1, Ms. LaPlaca, was the verdict that we heard the 4-person read here in court your verdict in the jury room? Did you freely and voluntarily enter into that verdict? Is it still your verdict? Mr. Brown, was the verdict that you read in court as to Mr. Williams your verdict in the jury room?
Yes.
And did you freely and voluntarily enter into that verdict?
Yes.
Is it still your verdict?
Yes.
Mr. Henry, was the verdict that was read here in court your verdict in the jury room?
Yes.
Did you freely and voluntarily enter into it?
Yes.
Does it remain your verdict?
Yes.
Ms. Carter,
Yes.
was the verdict read in court your verdict in the jury room?
Yes.
Did you freely and voluntarily enter into that?
Yes.
Is it still your verdict? Thank you. Mr. Baquet, was the verdict read here in court your verdict in the jury room? And is that something you freely and voluntarily entered into?
Yes.
Does it remain your verdict? Ms. Kwanzaa,
Yes.
was the verdict read in court your verdict in the jury room?
Yes.
Did you freely and voluntarily enter into that?
Yes.
Is it still your verdict?
Yes.
Ms. Holloway,
Yes.
Was the verdict read in court your verdict in the jury room? And is that something you freely and voluntarily entered into? Is it still your verdict? Ms. Booth Fuentes, was the verdict read in court your verdict in the jury room? Did you freely and voluntarily enter into it? Is it still your verdict? Ms. Anderson,
Yes.
was the verdict read in court your verdict in the jury room?
Yes.
Did you freely and voluntarily enter into it? Is it still your verdict?
Yes.
Ms. Dowridge,
Yes.
was the verdict read in court your verdict in the jury room?
Yes.
Was that something you freely and voluntarily entered into?
Yes.
Is it still your verdict?
Yes.
Ms. Davis, was the verdict read in court your verdict in the jury room?
Yes.
Is that something you freely and voluntarily entered into?
Yes.
Does it remain your verdict?
Yes.
And Ms. Ward, there you are. Was the verdict read in court your verdict in the jury room? Did you freely and voluntarily enter into that verdict? Is it still your verdict? All right. Thank you all. Here's what happens next for you. You're going to return to the jury room. We will return your electronic devices. I have a letter for each of you that documents where you've been in case you need that for work or to prove to someone at home that you haven't been playing hooky or whatever. I'm also going to come back and thank you for your service. And I have a couple questions for you all. You can ask me questions. And we'll return the most fancy Tupperware I've ever seen to you. And then you'll be able to go. But I want to thank you on behalf of everyone involved, the state and both defendants, for your service. You gave us 4 days of your life doing something that hopefully you now understand was very important. This is a case that we needed members of our community to decide. The police don't arrest and that closes it. The DA doesn't charge and that closes it. We need folks in the community to hear the evidence and to decide from that evidence what happened in the situation. And that's what you've done. It's an important responsibility. It's a serious responsibility. And we have no doubt that you took that responsibility seriously. And so thank you for your service. If you'll go with Deputy Gordon, I'll see you shortly. All right. Mr. Tolbert, it's a good day for you. I don't know if you have other things holding you in custody. If you do, okay. Right now, you just listen, okay? If you have nothing else holding you, then sometime tomorrow you ought to be released. I don't know if you're going to be reunited with all your stuff that was in 7 South 114, but who the heck cares, because you're going home. My counsel to you is don't hop in a car at 3 a.m. anymore. You have a chance to head in a different direction. It sounds like your life was real difficult leading up to this situation, and that you were bouncing from place to place and just looking for a roof over your head, and that you may not have caught a lot of breaks in your life. I hope that going forward, you learn from this and where you spent the last 4.5 years and say, I'm not going back. Be with your kids, be with your family. And I hope that you're able to chart a different course. Okay. What would that be?
My mom was in the hospital. My brother was laid up with cancer all over. My daddy just died. So I don't really have nobody out there. You know what I'm saying? After going through this case for 4.5 years, I actually lost everything. Little junk I did have. You know what I'm saying? I'm asking you since I can help put the pieces back together. You know what I'm saying? I'm too young to be out there like this.
I agree. So what I'll do is coordinate with the sheriff and see what they've got going on with their reentry piece. But I'm going to repeat what I said is that you're going to get out there and you're going to have degrees of freedom you haven't had in a while. You got to be real thoughtful about what your first few steps are, because you don't want to end up right back where you were because you were rolling with the wrong folks. I know you know what I'm saying. And I'm not saying it's easy to do that, but you're getting one of the biggest second chances someone can get. And I am hoping that you embrace it. Okay? All right. Mr. Francis, thank you for your service on this case. I know you came in late. You were able to move it forward in a way that it didn't for a number of years. All right. If you all could get Mr. Tolbert back there, please. Mr. Trepanier, do you have an opinion as to whether we should try to sentence Mr. Williams today or have him brought back tomorrow? Or I'm going to ask Ms. Feely in a minute. She may say we need a week to get someone here, but what's the state's perspective on timing for sentencing?
Mr. Fluid's father is here from out of town. I know he'd be obviously available. He's been here throughout the trial. I know he'd be available tomorrow as well, I believe. But I think after that, it would require him to travel back and travel. So the state would ask that sentencing either be today or tomorrow.
Okay. Ms. Feely, what's your perspective on today versus tomorrow?
There's not gonna be much of a hearing because there is only one sentence available, so we don't, we're gonna do it now.
Okay. I want to be able to release the jurors. But I'm going to interact with them for a little bit. I don't mind if really, maybe I need to get sheriff input here then. If we did sentencing in 15 or 20 minutes, does that work? Or should we do it, have Mr. Williams brought back? Don't all speak at once. I'm looking at that. You got all the brass on you. You're good. Do it today? Okay. Then if we could have Mr. Williams go back into lockup, we'll bring him back out in just a little bit and just close this out. Thank you. Okay, Ms. Rivers, you ready? We are back on the record in State versus Williams. The jury has returned a guilty verdict as to all counts. Mr. Trepanier, I'm ready for your recitation of what you think is vacated and what merges, et cetera, your recommendation, and then if there's any victim impact information that Mr. Flewitt's family would like to share, either from them directly or through victim witness advocate or through you. Now is the time for all of that. And then I'll hear from Ms. Feely, and if Mr. Williams wants to share anything, I'll hear from him.
And Your Honor, at this time, the state would tender into evidence State's Exhibit 116, which is the people of the state of Illinois versus Ramel Williams certified statement of conviction disposition out of the Circuit Court of Cook County, Illinois, in case number 09 CR 0052601. And the state would be tendering that into evidence for sentencing purposes today.
So just one, there were 4 convictions listed in the recidivist notice, if I'm remembering correctly.
2 have been admitted into evidence as part of the trial, and the state would also be moving to admit State's Exhibit 117, which is the certified statement of conviction disposition and the people of the state of Illinois versus Ramel Williams out of the Circuit Court of Cook County, Illinois, in indictment number 11 CR 0887101.
All right, Ms. Feely, any objection to the admission of those 2 documents, 116 and 117?
Yes, Your Honor. There's not an indictment in these documents. There's just like docket notes. So there's no signature of an attorney or anything to prove. It's just docket notes.
Okay, I guess I'll need to look at what 116 and 117 are.
And whether they would qualify for this felonies. Qualify as felonies anyway.
Can you make sure your microphone's on? Thank you, Ms. Wood. So every jurisdiction is different. I've come to learn that. 116 and 117 are official records from the clerk of the Circuit Court of Cook County, documents entitled Certified Statement of Conviction / Disposition. It does appear for the most part to be the equivalent of a docket printout. But it is a certification of conviction, and at the very end of both 116 and 117, there is a disposition for the charges. There's a sentence that is provided in 116 and 117. The sentence for 117 is a 6-year sentence. That says to me felony for a single count. And the sentence in the case set forth in States 116 is 1 year, but it's years and not months. That says to me felony. However, the state needs 3 and not 4 felonies. And you may have evidence, Mr. Trepanier, that the charge in the case represented by States 116 is a felony. You may have independent evidence, but one way we work at that circumstantially is to look at the sentence. But if States 112 and 113 are pretty clearly felonies, then it's a little less critical. What I find as to States 116, and again, States 117, it was a 6-year sentence for 1 count. So I find that's a felony. Anything you want to add as to States 116?
Yes, Judge. The code section or the section of the Illinois statutes that it references is 720 Illinois Code Section 570/402C. And that does specifically say that any person who violates that section with regards to an amount of controlled substance is set forth, is guilty of a class 4 felony. And so it also constitutes a felony in the state of Illinois. And as your honor is aware, just based on the sentence itself, it is in a term of years and not a term of months.
Okay. I think Ms. Feely has preserved for the record a challenge both to the sufficiency of 116 and 117 as proof of a certified conviction. That was part of her challenge. And then she's preserved as to both whether, even if this is a sufficient certification of a conviction out of Illinois, would these be felonies? I don't think there's going to be a whole lot of argument as to 117. I'll take judicial notice of statutes in another jurisdiction. And I find that 116 is a felony as well, but that's preserved should this be explored further on appeal. But I will admit states 116 and states 117.
And just one other thing, we don't think that there's sufficient evidence in those documents that he was represented by counsel. So I just wanted to add that.
Okay. Preserved.
Thank you.
Mr. Trepanier, what's next?
As it relates to what would Mr. Williams would be sentenced on as it relates to vacating counts and merging of counts. As the state reviews the charges, counts 2, 3, 4, and 5 are each felony murder counts. Those felony murder counts would be vacated by operation of law. And counts 8 and 9, which are the possession of firearm during commission of a felony and possession of a firearm by convicted felon, OCGA 11131, would merge with count 10, the 133 count.
And the armed robbery and aggravated assault.
Your Honor,
The armed robbery is merging into something. I mean, I'm sorry, the aggravated assault is merging into something.
I think the aggravated assault would merge into the count 1, the murder. And I believe count 6, the armed robbery, would remain, as that contains elements that are not contained within the murder itself.
Okay. And and you said 8, and that takes care of 8 and 9. So sentencing then, from your perspective, would be count 1, count 6, and count 10?
That's correct, Judge.
All right. And your recommendation as to count 1, given the recidivist notice?
Life without the possibility of parole.
Okay. And 6?
Life without the possibility of parole.
And 10?
15 years to serve consecutive to count 1.
And is your recommendation that 6 be concurrent with 1 or consecutive with 1?
Yeah, I would run that concurrently, Your Honor.
And does count 10, by operation of that statute, have to run consecutive, or you are?
That's correct, Judge. 133 is required to be run consecutively to other counts.
Okay. All right. I understand that. And how about any victim impact information?
Your Honor, Mr. Frank Fluid Jr., I believe, wishes to give a victim impact statement.
Okay. Mr. Fluid, I'm going to ask you to stand next to Mr. Fawcett. If you think you can be loud enough, if we need, we'll angle the microphone towards you. I need to make sure that Ms. Rivers can hear you. And this isn't an easy time. It maybe you don't want to speak up a whole lot, but why don't we try it right there? That'll make it even easier.
I'm not,
Great.
I'm not gonna take up much more time, but okay, I'm sorry. My name is Frank Fluid Jr. First name Frank, last name Fluittjr. Jr.
And you should take as much time as you want, so we're clear, okay?
Yes, sir. Understand. I'd like to thank the court. I'd like to thank the prosecutors. You guys did an outstanding job. I'd like to thank the family advocate. I'd like to thank the whole county of Fulton County for everything that you guys did to bring justice for my son.
Frank was my firstborn son. He's my first child. And he was very timid, wouldn't hurt anybody. Very soft spoken, much like myself. We sound just alike. He was a good guy. He was a good boy. He was an outstanding man. He went to Morehouse, earned a college degree, and he was on his way, trying to find his way in life, just like everybody else, to become a productive member of society. You know, when we all had children, we watch them born, we bring them into this world, we nurture them, we take care of them, we protect them, and we don't want anything to happen to them. And it's the hardest thing in the world to watch them walk out your front door, because they're going to be on their own, and they're going to come across people like inmate Mr. Williams over there. You're going to come across people like that. And you can't protect them. You can't be there for them. You can't protect them anymore. And it's hard. And every night, ever since this happened, I wish that it was me on that road. I wish that it was me that they came across. I really do. Because as a father, that's how you think. So what I would like to just say is, please make it that this man doesn't walk the streets anymore, so that he doesn't hurt anybody else's family like he did mine. My son had a daughter, and he had people that loved him very much. And that man took it away from him. He took him away from all of us. And please don't let him do this to anybody else. It's not. It's horrible. It's a horrible feeling. I want to thank everybody. Thank you all.
Mr. Fluid, thank you for being here throughout the trial.
Yes, sir.
And sharing what you shared. You have to let go of the kid at some point and let him fly free. And then it's risky. I know you wanted to be there, but he was charting his own course.
Yes, sir.
Went to a great school, had a daughter. So I guess you're a grandfather.
Yes, sir.
How is his daughter doing?
You know, ever since this has happened, I kind of lost touch with his girlfriend. And you know, they at the funeral they took it really hard.
Yeah.
And it's been months since I've talked to him. His daughter has cerebral palsy, so she's a special needs child.
Well, maybe you'll be able to reconnect after this.
Yes,
We'll
I
see.
hope so.
But today is the end of one chapter. It clearly doesn't bring your son back.
Right.
But I hope that it's the start of healing of some of the wounds that you and your family suffered as a result of this. Frank III is a memory, and it's a good memory, and you need to cherish that memory.
Yes, sir.
But this shows you that he wasn't forgotten,
Yes, sir.
even though it took us a few years to get here.
Fine.
I appreciate your patience.
Thank you.
You're welcome. Anything else, Mr. Trepanier?
Nothing else, Your Honor.
Okay. Ms. Feely?
We acknowledge the mandatory penalty. Nothing else to say.
Okay. Mr. Williams, you have a right to be heard as well. If there's anything you want to say, you don't have to say anything at all, but I need to give you that opportunity. Is there anything you want to say?
Nope.
Okay. Mr. Williams, the jury found you guilty of all 10 counts. Your sentence on count 1, because of the recidivist notice that the state has filed and that I have found is adequately supported by the 4 certified convictions, is a sentence of life without the possibility of parole. Counts 2 through 5 are vacated by operation of law. Count 6 is also a sentence of life without parole. I'll run that concurrently with count 1. Count 7 merges with count 1. Counts 8 and 9 merge with count 10. The mandatory sentence for count 10 is 15 years to serve, and it must run consecutive to count 1. So it's a total sentence of life without parole, followed by 15 years. It may seem meaningless to you, but it actually does matter, especially since your circumstances could change going forward. but you get credit for all the time that you served. And will continue to earn credit as you move forward. You have a right to seek post-judgment relief or appellate relief, given the verdict that was handed down and the sentence that I just imposed. One way you can do that is by asking for a new trial. You do that by filing a motion for new trial. I'm going to ask Ms. Feely to confer with you, and she may have already done that. But if you have decided that you want to pursue a motion for new trial, I'm going to ask Ms. Feely to file that initial motion, and then she's going to step aside, because one ground for a new trial will be that Ms. Feely was ineffective. I don't think she was ineffective, but that will get argued. And you're entitled to a fresh set of eyes from someone who doesn't work with Ms. Feely to look at the whole trial to say, here's where the judge maybe made a mistake. Here's where Ms. Feely made a mistake. And that motion will be argued by a different lawyer who will be appointed to represent you. You don't have to hire anyone. If I deny that motion for a new trial, you still have an absolute right to have your case heard by the Supreme Court of Georgia. You need to decide, after talking with Ms. Feely, which of those you want to do up front, because you can go straight to the Supreme Court and skip the motion for new trial. You've got 30 days from the entry of the final judgment, or final disposition, which I'll enter today, to either have that motion for new trial filed or a notice of appeal. If you, as I said, go for the motion for new trial, you can still have the appeal. If you go for the appeal, there's no motion for new trial. When all of that is done, whatever you choose to do on the appellate front, you will also have the right to challenge your sentence and conviction through what's called a habeas action. That you'd have to do on your own. You don't have the right to an attorney for that, but that clock doesn't start running until you've exhausted all your appeals. So you actually, if the appeals don't go well for you, you'll get another bite at the apple of, did I get a fair and proper trial or not? Do you feel like you've understood what I just described about your appellate rights?
Yeah.
Okay. Ms. Feely, will you confer with Mr. Williams and follow his direction in terms of either filing a notice of appeal or a placeholder motion for new trial?
We have had those conversations.
Okay.
Yes, I'll follow
And
up.
within less than 30 days, you'll do one of those two things?
Yes.
Okay. Thank you so much. Mr. Trepanier, anything else you think I need to cover at this time in State versus Williams?
No, Your Honor.
Ms. Feely, anything else?
No, no.
Okay. Thank you, everyone.
Didn't see.